better for us, I believe, so to have more fresh air in the room. As your safety. It's great that we have such a great interest also for this pre-session. My name is Pencho Kuzev, and I work for the Department Analysis and Politics of the Konrad-Adenauer Foundation. As you know, when we talk about competition, there are basically currently two streams. The one stream is the so-called platform regulation and modernization of the rules at European level. And the second stream is more in the context of industrial policy and the so-called level playing field. We talk about level playing field in every possible occasion, mostly in respect to Chinese and US undertakings. And I have a great pleasure that Karolina Dacko is with us. She's attorney, comes from Sweden. She has more than 10 years of experience in the respective field, especially in the field of anti-dumping, foreign subsidies, WTO, but also in the field of security issues. Really on short notice, she did a good assessment, a perfect assessment for us, so to say, regarding the white paper of the European Commission and the three models that the European Commission has proposed in the context of the level playing field. It's a great pleasure that you are with us, that you make it from Stockholm yesterday evening. The floor is yours. Many thanks.
Thank you. I have some slides as well, I think. Where is there we go, look, magic. And I think, did you choose the theme of the summit because I'm Swedish? The winner takes it all is a very famous ABBA song. No. I can joke as well, but let's go to serious matters. The European Commission's white paper on foreign subsidies. So as Pencho mentioned, it's actually not 10 years, it's actually more like 18. 10 years is in Brussels. The rest of the 8 is in Sweden, helping Swedish companies with trade law matters. And what we see is going from the traditional field of trade remedies, so anti-dumping, anti-subsidy, customs duties, and with all that's happened with geopolitical events, Donald Trump in particular, China, and on the other hand, we see a lot of it going into what's called national security. And one of the things of the white paper is the movement towards a foreign direct investment screening. And we'll get to the correlation between this white paper and the European Commission's new rules or the new regulation from the EU on foreign direct investment. So with that, could you please check the next slide? Yeah, and you can take the next one again. So being a trade lawyer, I have the particular focus coming from the WTO and the anti-subsidy regulation in the EU. So just to understand the white paper, before we go into the actual content of the white paper, I thought I'd give you just this backdrop, the context of the white paper. Where is it coming from? Because I think that's very informative. I found myself when I was reading through this to understand the actual content of the white paper and what it is the European Commission is trying to achieve. So subsidies and trade distortion. We all know subsidies can be very, very useful for industrial policy, developing countries, developing new technologies, R&D, greenfield investments, and so on. So subsidies can be something good, but it can also have very distortive effects on trade. So when the WTO was created in 1994, we already had, since 1947, the GATT negotiations. Subsidies, we weren't really agreed on how to treat them and how to define them. And it was first in 1994 with the WTO so-called ASCM, so Agreement on Subsidies and Countervailing Measures, that the WTO members agreed on how to treat subsidies. 2 rules were set, very important. Lots of different rules were set, but 2 important for understanding the white paper. The first rule is on transparency, understanding what other countries' subsidies exist. So in the rules, in Article 25, each member has the responsibility to notify the WTO on what subsidies it actually applies to its industry or in its domestic territory. That has been a complete failure, by the way. I'll come more to that. The second important distinction to remember for the purposes of the white paper is that the subsidy agreement makes up two categories, actually three, but it's not so important for the white paper, but two important distinctions. One is prohibited subsidies. These are the most harmful subsidies that exist in international trade. The first category of prohibited subsidies is export subsidies. So a country giving money to industry or companies to actually go sell abroad. Of course, for other WTO members, that's particularly damaging because you're damaging my industry in my country with the help of government money. So everybody agreed that's completely prohibited. The other type of prohibited subsidy is when you're saying to your industry at home, use local content. Make up rules to say, maybe you get a tax incentive to use local produced instead of imported goods. Those are also prohibited. Why are these important to understand? Because the WTO system gives members the right to act immediately on such subsidies. You don't have to show that there's a harm to your industry. So I think I've hammered that point in very keenly. Now, the other category of subsidies that the ASAM agreement put forward is actionable subsidies. These are all the other type of subsidies that are listed in the ASAM agreement. With those subsidies, you have to show that if another government is sponsoring through actionable subsidies their industry and it's harming your industry, you have to show that there's some form of injury or damaging effect for you to go to the WTO and say, I want a remedy. Or, in the case of countervailing measures, imposing a duty on the products that you import from that country. So just remember the point on prohibited and counter-actionable subsidies. So the ASEAN agreed in 1994, everything good, right? But no, the world didn't evolve completely that way. There are very well understood limitations to this agreement. So it only concerns imported goods. A member of the WTO, the only way you can actually counter at the level of industry, so European industry, the only way they can go against imported goods or using the subsidies agreement is filing for countervailing measures, asking the European Commission to investigate and then impose duties, countervailing duties. That levels the playing field. It's supposed to take out the subsidy from the price of the product so it comes to the same level as European industry. So it doesn't, in effect, cover any form of services or data or technology that's provided perhaps free of charge to European customers. So the competition on the European market, we all know that we're going toward a digitalization whereby the real value, maybe the highest price, is actually not in the physical product anymore. It's more towards the services and the data you're able to provide and produce. That's where the real value added is. That becomes a problem. The other problem, perceived problem, in the WTO context is that we only have these two categories of prohibited subsidies. Europe, US wants to list more. And it's not so strange if you consider the way the Chinese economy is actually evolving and how it is structured. Lots can be said about the market economy principles and so on. Europe, Japan, and the US have tried to push forward for new rules in the WTO context, but we all know that WTO has more or less collapsed. There are no real negotiations on new rules on subsidies. So what happened? These three parties went out and have gone together and grouped together to try to reform the subsidies regimes. So the EU, Japan, and the US have met in tri-party negotiations to try to develop the subsidy rules. In 2018, they went out together and came up with a definition of what is actually a market economy without proper subsidization. What are the proper principles and signals to show that this economy, this market is working without distortion? Then this year, actually, in January, the three parties agreed on a proposal to reform subsidies. One of the proposals was actually to largen the list of prohibited subsidies. The other one was on transparency, to say, if a member of the WTO doesn't notify what subsidies it applies, they're considered prohibited from the starting point. Why? Because it's so difficult to understand and see through the structure of an economy from the outside to know where, if at all, there are any subsidies and how to net back and peel away the layers to understand, is this product, service, supply benefiting from a subsidy? It can be disguised in various different ways. So the EU, again, Japan and the US have put forward this proposal. And now we're standing here with the EU sticking out its chin on what it wants to achieve. Now we change slides, please. Okay, so the key concepts of the white paper. This informs what we see, what the Commission is proposing. We have a definition of foreign subsidy. I'll get back to that because that's one of the key findings of this analysis is it is a difficult definition to import into new EU legislation. The other key concept is distortion to the internal market. So what the European Commission is proposing is if there's a foreign subsidy and there's distortion, we can take redressive measures. What the Commission is also proposing is a list of predetermined subsidies that will also be presumed distortion. Not so strangely enough, the list of prohibited or the list of presumed distortive subsidies is exactly the same as the one that the EU has put forward together with Japan and the US in the context of the WTO negotiations. Hence, these are the type of subsidies that we see are particularly harming for global trade, and in this case, the internal market. For other types of subsidies, the ones that the Commission is proposing aren't presumed distortive. We have different type of market indicators, price, size, the type of investment, is it high tech, all those different type of variables that would decide whether it is extra distortive or not on the internal market. A lot of margin of discretion here. There is one important part though. Privilege on the domestic market of the company, or the domestic market meaning the government that is subsidizing, accused of being subsidizing. And I think here we come back again to the problem with China. There are a lot of companies that have a very privileged situation and can leverage economy of scale at another level than any fair competitive market economy companies can. So the targets and redressive measures that the Commission is proposing, there are three modules. One is a very broad one, a general one, and can target undertakings in the EU. So an undertaking, a company in the EU, receiving a subsidy, there can be redressive measures. Pay back the subsidy, or share your R&D, or there's a long list of proposed remedies to the subsidies, including then, as I said, repayment, but not to the government in question, but to the EU member states or the EU budget, which would be nice, right? This is a broader scope, but then we have the two other modules that are being proposed. Module 2 is the one which we see links back to the FDI screening regulation, which is entering into force next month, which regards acquiring companies, so investments into the EU. If you have a foreign entity acquiring, making acquisitions in the EU with the help of investments, with help of foreign subsidies, this is perceived as extra difficult. And to get at this, the Commission is proposing an ex ante notification. Basically, if you know competition law, a merger filing. It's comparable. you have to, if you think that there is a subsidy involved in this acquisition, in the funding of how to acquire the company. I know in Germany we've had a few examples of acquisitions that have been debated on how they were financed. Now, if there is a presumption or a suspicion that there is a foreign subsidy involved in that, or facilitating that acquisition, you have to notify it to the authorities, and you cannot go through with the transaction until it's been reviewed. Now, this is running in parallel with the EU FDI screening regulation and national screening regulations on whether an investment could harm security or public order. So a lot of red tape, but I'll come back to that in the recommendations part. The third module concerns operators that are participating in public procurement. Again, if there's a foreign subsidy involved in the bidding procedure for a public procurement deal, there has to be a notification and again a review and redressive measures. Redressive measures in this case could be one, if there's a subsidy involved in the public procurement, you get kicked out. That operator cannot participate in the tender. Or if there's a firm involved in bidding for a company, there's a foreign subsidy involved, the deal could be prohibited or annulled, and you won't see the transaction go through. Next slide, please. Okay, so one of the key concerns I have after analyzing this and working with the concept of definition of subsidy is actually this definition, how it's evolved under WTO case law in this fora of WTO tension between how you discover, how you don't report subsidies, and you try to understand and peel away the layers to look at whether there is a foreign subsidy involved or not. So the agreement, as well as EU rules on countervailing measures, have a definition of a foreign subsidy where it's linked to, either has to be shown that it is the government, so the top box here on the little picture, or it can be a public body that has the right or is invested in giving away or granting the subsidy. Now, the way the WTO case law has evolved, actually in a case that China brought against the US, made it very difficult for an authority to prove that even state-owned entities, so the Chinese state owning banks to 100%, or other government entities or companies to 100%, there's no presumption there that it's to say that it would be a government financial contribution in those cases. They're not qualified as public bodies just because there's ownership. Now, instead, you have to then, going back to the peeling of the layers, you have to look at the facts of each individual transaction to understand, was this bank or whatever company instructed by the state? Was there meaningful control, that's the terminology used, over that entity to direct the subsidy to the company who gets the benefit? This is inherent in the WTO case law and quite difficult to prove. The EU's approach to this is doing exactly that, going in and peeling away each and every layer. So there's an interesting case, glass fiber case that came out 2 days after the white paper came out, which goes through Chinese subsidies in extreme detail, I would say, explaining all of the criteria under the WTO rulings to say, well, here we had a bank law, we had directions, we had 5-year plans, and then on top of it, the loans that these companies got, they were all very, very favorable. So proving ownership plus a legal framework plus directions from the CCP, and then also proving the facts. Very, I would say, very heavy burden of proof for the European Commission. At one point, it was also based on non-cooperation because these banks didn't want to reveal the information. So they had to go in and say, well, you're not cooperating, so the facts as we have them, what we have, will be sufficient for now because you're not rebutting what we're saying. Now, this whole problem of having to prove so much, do the investigation, will of course also be subject to judicial review. So this could go to court, EU courts. There is an appeal against the glass fiber case in the general court. So we don't know if this whole method will work in the long run. It's still, I would say, up for discussion. The US still considers these WTO rulings as very unfavorable for using the ASCM agreement. And in this case, this is the easy example. Can we switch slides? This is what we probably are looking at under the white paper, what the Commission is proposing, if we're using the example of foreign subsidy in the white paper, if we just implement the same definition. You probably won't see a subsidy directly from the government, say China, directly to subsidiary in the EU to buy or to provide a service. The subsidy will be given through, for instance, a bank or some other entity, to a parent company who might have subsidiaries elsewhere, who in turn has other subsidiaries. How are you going to peel away all these layers and prove that that subsidy has been given to that particular company in the EU? And how will you be able to show that that has harmed the European market, the internal market? It's a very heavy burden of proof to have to do every time there's a claim of a subsidy. And this is what you get if you're taking the definition of foreign subsidy straight off from the WTO. I'd say, in my personal opinion, it's a brave choice for the European Commission to use that example. But hey, they can go it alone and try. Let's see if it gets tested in the WTO or in the European courts. Next slide, please. Turning to another point of the analysis is the distortion part. We talked about this. There's a list of prohibited subsidies or subsidies that would be qualified as extra distortive, and therefore you don't have to show a negative effect or harm on the European your internal market. Just to give you an example how it works under the ASAM agreement and under the EU rules, there's a set list of indicators for European industry. So you're looking at profit, at capacity, at production, market share, and prices, and a lot of other indicators as well. But there's a set list to go through and see how are our European industry faring? How well, good or bad, are they suffering? What would happen if we removed the subsidized products from the market? And then you check how much is the injury margin. So it's a mathematical calculation, basically. And it's a very transparent way of doing it. There's a required causation. Has this injury been caused by the subsidized imports? And there's judicial review. You can go both to the European courts and you can go to the WTO. I mean, the governments can go to the WTO. So there's a test of whether this was a valid determination on injury. The closest thing to injury we have here is this concept of distortion. And in my view, it might be a little too open-ended. Apart from these prohibited subsidies / predetermined distortion, do we have sufficiently clear idea of what it is we're saying is a harmful effect on the European market and in the internal market? And in each of these three modules, there's a different assessment. So the more unclear it becomes, as a lawyer, I see the risk of this going to court and being kicked out. This was a wrongful assessment. There wasn't a protection of due process. The parties couldn't understand what it was they were facing. Could they have had a chance to provide more information? And then we have this concept of privileged access to the domestic market, this economy of scale, leveraging the fact that you have a completely protected market on your own domestically, and then you can leverage that to sell things in the EU. And there might not even be a proper subsidy that you can detect in the background. For me, this privileged access to the domestic market, I think actually it should belong as a part of the subsidy definition, that there are rules in place that give companies the privileged access. instead of making it a distortion assessment part. But it's good that it's there somewhere, but I think that will be very difficult. Okay, so last slide before we turn to questions. Recommendations. I think it's pretty clear what I'm saying and what I think should be there. One is looking at the definition of a foreign subsidy. Maybe look again and think through, do we really want to import all of that case law and that political tension and the risk of judicial review being tested in the WTO into this legal instrument? The other two are pretty evident from a lawyer's perspective. Make sure that there are clear procedures and ensure that there is due process. There, I think we could borrow a lot from the anti-subsidy regulations in the EU, because there are very clear, both anti-dumping and anti-subsidy regulations, because there are very clear set procedures. How do you go through an investigation? The other concept is, that I think is very important to define, is distortion. It's a little too open-ended, a bit too vague right now, and it should be more or less clearly defined and a set structure. The last point, and this is probably just from a law firm perspective, on how to advise companies when you have 3 new possible regimes that you have to think through if you're seeing an investment from Asia, or elsewhere from that matter, you don't know yet. Because under Module 2, the European Commission is proposing that they will be the one reviewing foreign investments with a possible foreign subsidy in it. So you have to notify for the reason of the foreign investment. You might need to notify because there's a possible connection to the FDI screening regulation on public security or security and public order, touching on critical infrastructure, to critical technology, and so on. And member state screening rules. And you will have your traditional merger filing regulations. So you'll look at 3, maybe 3.5 or 4, depending on what member states have their own FDI screening regulations for a foreign investment. So maybe have a look at how to synchronize at least those two on foreign subsidy and the FDI screening rules. But this is a matter of competence, I think, which is a completely different discussion. But this will put a lot of strain on investments activity and be a deterrent factor, for sure. Just the red tape. Thank you.
Many thanks, dear Carolina. Impressive recommendations by you. Please take your seat. I have many questions, but where to start? Having in mind that we are at the European Data Summit, all these proposals by the Commission, do they have in mind the specificities of the digital world? That would be the first question. And the second question would be, do we really have a problem? I mean, from the German perspective, we're hearing a lot, also in the context of the industrial strategy. Also, there are some French initiatives in this regard. What do you think? Is really the time to go this way, to regulate more strictly and to address all these issues?
What I think personally, or what I think from the perspective. Yeah, from a practitioner's point of view, of course, more regulations usually means more work for us. But at the same time, what we want and what our clients usually want, companies investing or being invested in, is predictability. So overlapping regimes, I'm starting with your last question, overlapping regimes, different regimes at the same time, it is cumbersome. It will be cumbersome. So begging to make rules as clear and predictable as possible. And one thing that always comes up in these M&A or merger and acquisition transactions, one, what are the sanctions if we don't do it right? What is the timeline, and what can we do right now to prevent or to fill in the information that's needed? So predictability is the key aspect of the whole thing. So if there are rules, make them clear.
Okay, and regarding the specificities of the digital economy, do they have in mind all the data aspects?
This is a very good question. So data in itself, if we reason about it and what the white paper addresses, it goes, of course, beyond physical products. So yes, we have services would definitely be covered by the proposal. We have technology, if it's provided free of charge. Of course, that could be a disguised subsidy or a possible subsidy. And then data, if you're providing data as such, I'm not really sure where it falls exactly, but for sure the proposal goes much beyond what is physical products, which is a good thing.
Okay, that's good to hear. Maybe we have questions from the audience. Wolfgang Kopf, nice to see you in the audience.
Well, first of all, thank you for this really clear and comprehensive presentation. I learned a lot. Thank you. 25 years back, I did trade law, but since then I never followed up, so I recognize some of it. And that would be also my first question. Much of that has been addressed in the past in anti-dumping laws. You only touched upon this very shortly. Isn't that also something we could tackle with anti-dumping? And in addition to that, you were elaborating on the rule of law in these fields. If I look at the US, if I look at China, the judicial remedies are very limited. I mean, the US has now introduced it at the security part some possibilities to sue the United States in the CFIUS procedure, but that's it. And the very nature of trade law was not that you are ending up in local courts, usually. Now we have a dead man walking called WTO. Why should the EU then have an elaborated rule of law on such laws? Because that's just, I mean, don't misunderstand me. I'm really behind rule of law. Yeah? But in trade law, the rules were always a bit fishy in order to achieve the things you wanted to achieve. Could you comment on that?
Yes, I'd be delighted to. I'll start with the rule of law and the trade law question.
He's a representative of Deutsche Telekom for how many years at Public and Regulatory Affairs? More than 25 years? About. So he's quite
good. Thank you. So on the rule of law aspect, I think this is beyond a lawyer's world. I think this is something we have to consider from a European perspective. What is the EU's role in this trade war, or even beyond that geopolitical war between China and the US? What values is it that the EU represents? Well, we stand up for the rule of law, for democratic values, for freedom of speech. GDPR is one of the perfect examples of a law that actually the EU has championed and put out there. So when it comes to these type of rules, we're going to apply them to entities in the EU. This is our jurisdiction. And we have the statute, so human rights, and that includes rule of law, due process, judicial review, all that full library, all those rights. And we have to, it doesn't rhyme well unless we protect those rights, even if we consider this to be a trade law instrument or trade policy instrument, for that matter. If it's in our jurisdiction, we need to uphold those rights. Otherwise, it's a matter of hypocrisy in my meaning. And the first question was anti-dumping, right? Yes. Well, anti-dumping is company specific, right? Or specific. It's just at the company level. You can't use anti-dumping measures to get at subsidies in the same way, because you have this new Yes. But the idea with having both the two regimes, the anti-subsidy and the anti-dumping regulation, is that you use the one for the dumping and the other one for the subsidies. So possibly you could use, under the new EU rules on market distortion, after China was not granted market economy status and brought it to the WTO, retracted, now we can use market distortion in anti-dumping cases as well. But again, both anti-dumping and subsidies, it's only the physical products. It's only customs duty on products crossing our border. We cannot do anything with that on subsidies or dumping that's occurring in the internal market. So it's a very small instrument.
We have one more question, and then we have to finish. Please.
Hello, my name is Stefan Herwig. I run a small internet governance think tank. I'm looking at we're looking, trying to make a scientific look at the platform economy and trying to make a read of it. I highly appreciate that you look at this field in terms of subsidies as well, and not only in the field of anti-competition, right? We also have an interpretation on why the market output is the way that it is, and we do think that subsidies play an essential overlooked role to an extent that it makes markets fail. Have you considered political ill regulation also as to look at it from a point of subsidy? I will give you a very simple example. Taxation, for instance, right? Right now, the legislator on a European scale has not been able to sufficiently tax large digital companies, right? That discussion is going on for years now, right? And obviously, this could also lead to a considerable market distortion, right? So I would like to ask, what your opinion is on that, because I think, yeah, we have failed to tax these companies. It distorts the markets completely, and obviously the tax subsidy gets bigger the more profit these companies rein in, right? So if you give somebody a tax subsidy and they're a small business, yeah, okay. And the other issue is, have you looked at the occurrence of market failure in general, right? Not only from an anti-competition standpoint, but also, whether there are subsidies that cause entire markets to fail, because I do think that when we look at platform economy, we have multiple market failure. So.
More general question.
Thank you. Comprehensive questions, thank you. So market failure, no, not the concept as such. I haven't looked at that. I think the closest we get to that is probably the comparison to the privileged access on the domestic market, so the foreign market we're looking at. And yes, tax subsidies, subsidy can be tax reduction or failure or whatever, how you present it, but a state that does not tax or give tax preferences, that can be a subsidy. But again, we're not looking at the EU market, we're looking at internal market on how the EU has been doing it, or different member states, that's a problem. We're looking at it from the perspective of what foreign governments are doing in terms of companies that they would be giving a financial contribution to. So normally governments in foreign countries would be giving tax benefits to the companies under their jurisdiction.
Many thanks. It was everything impressive. We have promised to deliver the paper in timely manner till end of October. So the European Commission, the German government, has enough time to evaluate our recommendation and our discussion. And it was really a pleasure to listening to you. Many thanks. We make a short break of just a couple of minutes, and then we continue with the official part of the European Data Summit. Many thanks.
Test. He. Aha. So. 7, 8. 1, 2, 3, 4. Kommt an.
Shall we start? Wir müssen weitermachen. Nice to see you. I thought we answered the question regarding the your involvement, and you're writing me. I said, oh my God, why? Doesn't matter. You, could you please cut the break, please? Let me show one book over there. I'm sorry for the short delay, but we have to continue, especially because of the live stream. But I think the previous presentation was that impressive that we have justification why we prolonged the time. Ich sag gleich. Dear guests, welcome to the European Data Summit 2020, also to our audience on the live stream. My name is Pencho Kuzev. I work for the Department Analysis and Consulting of the Konrad-Adenauer Foundation, and I'm going to navigate you through this event in the next 3 days. This event takes place in the framework of the German presidency of the Council of the European Union. My special welcome to our European guests, which despite corona restrictions made it to Berlin. Some of them even did a negative corona test in order to be able to join us in these 3 days. I really, really appreciate this. Maybe many thought maybe we should cancel this event because of the pandemic. However, some topics cannot be postponed. We want Europe to be more competitive after the crisis, and more than ever, competition matters in the European digital economy. As you have noticed, the Federal Minister Altmaier is not able to be in person with us tonight, but he has find a time to provide a message by his representative, Thomas Jetzombeck. Please, the video message of Thomas Jetzombeck.
Welcome you today on behalf of the German federal government to the third European Data Summit at the Konrad-Adenauer Foundation. Our Secretary Peter Altmaier would have loved to join you today, but unfortunately he was not able to make it. He sends you his best regards, and also me, as this is a topic of my heart. This year's conference is entitled "The Winner Takes It All." It addresses the specific competition-related problems of the digital platform economy, which we have been discussing intensively for some time now. Basically, we are talking about the question whether we need competition law instruments which are better tailored to tackle these challenges, and if so, what would be the appropriate instruments? In my opinion, and also from the federal government's point of view, the answer to this question is clear. Yes, we do need such focused instruments. And we also have a clear idea of what these instruments should look like. They must be effective and enable competition authorities to respond to the challenges caused by platform markets without lengthy procedures. Ladies and gentlemen, the Act Against the Restraints of Competition, the basic law of our social market economy, is the German model instrument to protect competition. In addition, we have equally effective competition rules at European level. In view of the specific characteristics of the digital markets, however, we still need to modernize our competition law. It must become faster, more effective, and even more targeted so that we can successfully tackle the new challenges. In short, we need a competition law 4.0. For this purpose, we need to build on the latest research findings on the mechanisms of the digital economy. And we need to take account of the experience gathered by the European Commission and the Bundeskartellamt with the proceedings against Google, Facebook, and Amazon. I believe that we are making good progress on this. The latest initiatives taken by the European Commission are very ambitious. They are addressing challenges related to both globalization and digitalization. The Commission has submitted proposals which are bold answers to these challenges. I very much welcome this. On this basis, we now need to jointly find and implement convincing solutions. In this context of the new competition tool and the initiative to introduce stricter rules for large gatekeeper platforms need to be integrated in an overall concept. Ladies and gentlemen, we need an effective instrument to solve structural competition problems and possibilities for the European Commission to intervene. The federal government is using the German presidency of the Council of the European Union to actively foster this process. In this context, today's conference is also making an important contribution. It offers an opportunity for us to openly discuss how to design the instruments needed and outline possible solutions. At the same time, the federal government is pressing ahead with the amendment of the German competition law. On September 9th, we adopted the draft GWB Digitalization Act, the draft act to amend to the Act Against Restraints of Competition for a focused, proactive and digital competition law 4.0 and other competition rules. The aim of the draft act is to address digital economy issues in a focused manner, and particularly to develop the control of abuse of dominant positions. We thus ensure fair access to data and stipulate new rules for platforms with outstanding cross-market importance. This also includes a new criteria to determine a market-dominant position, the intermediation power. And we prevent markets from passing the tipping point, becoming monopolies due to unfair practices. With these instruments, we are pursuing an approach to proactively combat monopolization and foreclosure strategies on digital markets. These markets should be open to newcomers and continue to be open to them. The aim is to strengthen competition and thus the innovative capabilities of German enterprises and startups. So far, our draft act has been well received also in other European capitals. This applies not only to introducing stricter rules on the control of abuse of dominant positions, but also to the proposals of streamline merger control and increase legal certainty for cooperation. This innovative concept of the GWB Digitalization Act also reflects the German federal government's expectations of a European competition law 4.0, which strengthens innovation and fosters the competitiveness of our economies in this digital age. I wish the European Data Summit every success and fruitful discussions. Thank you for your attention. Stay healthy.
So unfortunately we had technical problems, but the people on live stream could follow Thomas Zombeck, A Strange World. Now it's my pleasure to welcome Andreas Mund, the president of the Federal Cartel Office. The Bundeskartellamt addresses the challenges of the digital economy continuously. If the amendments of the German Competition Act go through the parliament, the competences of Cartel Office will be definitely extended. to use a competition vocabulary, you will have a special responsibility for the digital markets in the future, the more. Dear Andreas, the floor is yours.
Well, ladies and gentlemen, dear Pencho, it's great to be here in physically. I mean, this is for the first time. I think the last physical conference I've been to was on 2nd of March. It was in London with Andrea Coscelli. And when we came there, the conference was set off. But the speakers were there. So we were standing in front of a huge room for 400 people or so. And there were only the speakers, so we had to give our speakers into the empty room, and it was streamed live. It was my first online conference, and I had no idea that this was the future then. So it's really great to be here. And it's always also great to see a couple of colleagues again. Natalie Hasdorf is here. From Austria, Johannes Lianos from Greece is here. Also a couple of clients, Mr. Kopp from Deutsche Telekom is here, and long followers like Philip Marston and others. I could mention others, so it's really great. I will be brief with my introductory remarks, and I will just give a little bit of an overview on what is at stake in the digital economy. And I will turn to the question a little bit, what about regulation? And what is the relationship between competition law on the one side, and what about regulating these markets on the other side? And what are the obstacles? And I will turn to that. And of course, I will come to the German Act that is about to be amended right now. Well, I think everyone in the room agrees that the digital economy brings a lot of benefits for the society. There's no doubt about that. I also believe that everybody in the room agrees that the digital economy poses a lot of challenges, not only to us as competition agencies, but in many areas it poses challenges. From my perspective, lots of things are not regulated appropriately. We have managed to regulate our offline world along the values that we have as a society. We have never ever managed to transpose these values and the regulation that we have in the offline world into the online world. So this is not only a topic for competition agencies, this is a topic for the society as a whole. And maybe one can say that competition law is a little bit ahead of the debate, and that we really try to do our homework in this respect. We also know about the characteristics of the digital economy. We have learned a lot about network effects reinforcing themselves. We have learned a lot about data-driven business models of so-called gatekeepers. We have learned that data-driven business models reinforce the network effects. We all know that. And this is the mechanism that leads in the very end to monopolies and to the phenomenon that the winner takes it all. Everything that I'm telling you here is not new to nobody in the room, I know that. But we had to learn that. I mean, think 5 years back. I always think back to a great conference that we had as competition agencies in the framework of the International Competition Network. That conference was in Porto. I think it was 2015. And I gave a speech on the digital economy. And there were colleagues from around the world asking me, do you really think this is so? And do you really think we face all these problems? That is 5 to 6 years ago. So you see, we have had an enormous learning curve over these years. But we had to learn. And it's also a fact that we have done a lot of enforcement during that time. We also started early on in 2013 with the price parity clauses of Amazon on the Amazon marketplace, together, by the way, with our colleagues from the UK OFT, as it was still called many years ago. Remember 2019, when we were dealing again with the Amazon marketplace terms and conditions, this time with our colleagues from Austria, and we could obtain huge, improvements on these terms and conditions for Amazon marketplace dealers worldwide, by the way, not only for Germany and not limited to Europe. Think of price parity clause cases with regard to the online hotel booking platforms, and of course the Facebook case that has just been confirmed in a preliminary proceeding by the Federal Supreme Court some weeks ago, where the Federal Supreme Court has confirmed our theory of harm to a large extent and said that Facebook abuses its power, its dominance, by forcing the user to hand over limitless the data they leave, not only on data but also on third-party platforms. So there have been big cases, in fact. There have been successful cases, and still the question is in the room, are we where we want to be, and are we where we need to be, or do we need to do more? If you take a look around the globe, there's divergence on these questions. Again, we just held our annual conference of the International Competition Network, where Margrethe Vestager eloquently presented the new competition tool and the Digital Services Act, and made clear that from a European perspective, it was about time to strengthen our toolkit, whereas our colleague, the Assistant Attorney General from the US Department of Justice in Washington, Macon Dalrymple, argued it was too early for any regulation and that we should wait what would come. So even on this question, you do not have convergence around the world. We should not forget that here in Europe, that there are people who think differently. I think this is important to have that in mind. To my personal mind, I believe there are lots of people, policymakers, users, consumers, citizens, who have the vague feeling that it should be us who shapes digitalization, and that we should not leave it to digitalization to shape our way of work and life. And I think this is exactly what is happening at that moment, because we have failed to regulate this new digital economy. It shapes us. It shapes what we do, how we act. We react for the time being, and we don't act. And that is a feeling. That is a feeling that many people in Europe have, which cannot be completely wrong if there are so many people who think so. And I think despite the big and successful cases that we have brought so far, it's about time to consider readjusting our toolkit. So we might need some regulation. The only question is, what kind and in what sense? It's a challenging task to design the digital economy. By intuition, what we first might want to do is we look at sector regulation, because we have a lot of experience. Look at telecommunication, look at electricity, grids and all that. We have a lot of regulating experience in these areas. But this is extremely different from what we should do and need to do in the digital economy, because here we talk about infrastructure. And infrastructure is rather coherent and it is rather static. But digital markets, digital business models are completely different from that. They vary to a very large degree, company by company, business case by business case. They are everything but static. On the contrary, they are highly dynamic. And how to regulate a highly dynamic market, that is not so easy. The first question you need to answer, who shall be regulated? Which company shall be regulated? There are two options. On the one hand, you can introduce a quite broad regulation, a variety of companies with general rules for platforms. But with more companies covered, regulation needs to be less intense, because we need to avoid over-regulation. We do not want to submit little companies, startups, who shall be potential competitors to the incumbents. We do not want to submit these companies to regulation. They must have a possibility to behave in a bad manner, maybe, to become a severe competitor, at least a less a less or worse manner than we want the incumbents to act. So we could target only a few companies. That is option 2. That would allow for more specific rules, for stronger interventions. But then it would become even more difficult to define exactly those companies whom we want to regulate. We have seen that during the debate about the new provision 19A in the Competition Act, whether it is limited to the digital world. Is it a provision that is valid for other companies in the offline world too? That is not easy to say. Deciding which behavior should be addressed adds to the challenge. Prohibiting harmful behavior per se has some appeal, but it is extremely difficult to define this behavior. Economics and experience tells us that competitive effects of strategies can be ambivalent, in particular in the digital economy. Moreover, I'm very hesitant to believe that a per se prohibition eliminates all uncertainties in practice. Just think about the prohibition of self-preference. I think we have an enormous agreement here in this room that maybe at least we should think about forbidding self-preference to so-called gatekeepers. Sounds great, no more self-preference by gatekeepers. But then the question follows, how do we define self-preference? And here remember the Google case, the Google shopping case at the Commission, where there was an ongoing or a very long discussion about any particular specific designs of the website that might lead to self-preference by Google or not. In the very end, it was a debate about the shades of a color on a certain website, that the change of the color might lead to self-preference. I'm telling this because just setting up a rule, self-preference is forbidden, will not solve all the problems. You still need a case-by-case assessment. So the questions are complex, but we have to find answers. Just because it's complex doesn't mean that we do not have to find answers. So we from the Bundeskartellamt, we welcome, of course, very much the initiatives that are ongoing in Brussels. The Digital Services Act, the new competition tool, may be still a bit vague, maybe not very clear yet. What is the relationship between the Digital Services Act on the one side and the new competition tool on the other side? But I think at least what we welcome very much is that we have a debate, and we can be very sure that we will have a decent outcome when this debate comes to an end, and that we are taking a way forward. Very happy also that we are at the eve of the amendment of the German Competition Act, the 10th Amendment, which from my perspective takes an excellent path because it bridges to a certain extent the divide between traditional competition law on the one side and traditional regulation of sectors or companies on the other side. It is a bit of regulation, but in the spirit and the context of competition law. The draft refers to companies with paramount significance for competition across markets. If you look into the Furman report, you find companies with a strategic market status. There was a long debate also in my office what would be the correct addressee. How do you define that? Was not easy. We thought of systemic companies, but systemic would have meant we cannot do without them, wouldn't have caught the case. So this is what we did. This is in the UK. The provision might look a bit different, but it's very close to each other. I think we took the right focus, that we only address certain companies, only defined incumbents. I think this is the right way to do it. And there are lots of clarifications in the law that might be very helpful if, and this is very important, if you want to bring your cases through court. And here, clarifications can help a lot. We can prohibit certain conduct, for example, self-preferencing, enveloping strategies. We can prohibit establishing entry barriers related to data. We can prohibit the hindering of interoperability and data portability. Still, the law cannot define what is self-preferencing. It cannot define what is an envelopment strategy. But to have these examples explicitly in the law will help a lot when you bring these cases to court, because you do not have to struggle for the theory of harm. You have to define the behavior, yes, but the theory of harm is put in the law. And I think this is what is so extremely helpful. Although maybe already now we can bring these cases to court successfully, we have seen that in the Facebook case, but these kinds of clarifications should be enormously helpful. A second feature of the law, I'm not going into details, are data related. I think this is also very important because data is one significant source for the dominance of these companies. So it is an excellent result that we can go easier into, for example, granting access to data of certain companies and other issues. The National Essential Facilities Doctrine will be widened and will explicitly cover data, access to data, also a good example. And last but not least, a third point in the draft is an update of the established rules for undertakings with relative market power. And here exactly relating to dependencies on intermediaries in multi-sided markets. And here also with regard to data. So in a nutshell, I think the 10th Amendment of the Competition Act deserves lots of consideration, not only in Germany, also beyond Germany. I'm not going to say it's going to be a role model, but it has lots of excellent ideas which are not limited to Germany, but which are worth to be looked upon also in other countries. The same way we look at what is happening in the UK, also with the Furman report and the development after the Furman report, very much at the forefront of the development. And that is one point that is very important for me. We can only learn from each other by cooperating. Before the amendment, I've been in the UK frequently, addressed these issues with Andrew Tyree, with Andrea Coscelli, with Philip Marston, others, and Taylor was extremely inspiring. And at least some parts of it you can see to a certain extent in the amendment. So it will strengthen our mission. I'm very sure it will help us to keep digital markets open and contestable, and it will help us preventing consumers from harm. And having said this, I'm very much looking forward to the discussion. Thank you very much.
It was a pleasure to listen to Andreas, as always. You have sent many clear messages, but also a lot of optimism that the current legislative approach goes into the right directions. Also some open issues when it comes to self-preferencing, etc. But that's why we are here to discuss all these issues. Maybe we take just one question and then we continue. Is there maybe one comment that who is ready to address? Please.
Use the micro? Yeah. Thank you very much, Silvia.
You don't need to wear the mask during the session in the forum. I'm sorry that I forgot to tell.
Silvia Karma is my name, and my question goes to the topic you addressed in the beginning. You said we have to look at what or who we want to regulate, but did you also look into the question who we don't want to regulate or who we don't want to over-regulate? So very specifically, what happens to business data transfers, which are not always specifically in a context of consumer data, or are data sets which are going through intermediaries but are not creating such a dependency as in other cases, but could be defined as systematic or as relevant market power due to these amounts of data which these companies are processing.
I think we need regulation where we need it, which means you need to regulate those who have market power to make it very easy. And I don't care vis-a-vis whom they have market power. It can be, the Facebook case was very much about the consumer, the relationship between Facebook and the consumer, but not only. We have made it very clear, and also the Federal Supreme Court, that it is also about competitors of Facebook who do not have the data that Facebook has, so they cannot compete significantly. That is B2B, that is not B2C. I mentioned the question of relative market power, where we have dependencies among companies. Data-driven can have different reasons, but data-driven is one of the key reasons. I think also in this sphere, we might need some more regulation. And we might want to do more in order to take care for a market structure, also among competitors, that allows for competition in the future. I mean, we always say we do not protect competitors. Of course, we do not protect competitors, but without competitors, we have no competition. I mean, I've never understood that sentence properly, but that doesn't matter. So I think everywhere where it is needed, and I think that is a good approach in the law, that we are not only talking about dominant companies, we are also talking about relative market power, we are talking about dependencies, and that in this respect we also might need some regulation. By the way, just wanted to mention that regulation is always in English, it's a different word, because for us regulation is regulation, sector regulation in a narrower sense. In the English language, regulation, the competition law is also regulation. So if I talk about regulation, I always talk about regulating companies, regulating Deutsche Telekom, regulating a energy supplier, you know. So, but that is not easy to say. Here, the German language is maybe a bit more nuanced in this respect. I never find a proper word for Regulierung in that sense. Okay.
Many thanks, Andreas. We will continue the discussion with you later during the presentation together with Philipp and Ruprecht. And many thanks for your inspiring words.
Welcome. Thanks a lot.
Ladies and gentlemen, now it's my pleasure to invite Philipp Marsden and Ruprecht Potsdam. Having in mind the excellence of the competition discography of Philipp Marsden last year, we couldn't not think of him when we thought of the potential study by Konrad-Adenauer Foundation. Philipp is also one of the co-authors of the Foreman report, needless to say, and really happy that we're continuing the tradition that you're for the second time with us. Many thanks, dear Philipp. Ruprecht Potsdam, in the competition world, I don't need to spend too much words on that. I think one of the most prominent academic commentators when it comes to the all prominent competition cases and instances in the past. For those who would like to understand more in a simple words what's going on in the Facebook case and in other cases, I really recommend his antitrust blog. It was really a pleasure to cooperate with them in the last 5 months. So when I think of the positive side of Corona, that was really this initiative and this idea to collaborate on this concrete project. And here is the product. We had a problem with the delivery chain, but as you could see, we have make it. Many thanks that you are with us today. I hope you're going to enjoy the lecture of the study. But now we have thought that we don't need to present the study in a classical way. It's much better if we discuss. And later we have a common discussion together with Thorsten Kerseweg and Andreas Mund. I have read the study, of course, a couple of times. And if I could summarize the substance of the paper, we basically have three parts. We have rules, we have principles, and we have enforcement. Let's start with the first part. Tell me a bit more.
Can you hear me okay?
Yeah.
All right. First of all, thank you very much, Pencho, and to the Stiftung to invite me again from my crazy little island. It's really nice to be here. As Andreas said, an in-person conference, but also in particular inviting me back, considering what's happening on my little island. Also from a health point of view. It's very nice of you to have me here. It was such an honor to be asked by you to work with Ruprecht on this study. The primary reason for me to be so excited about this is that we're combining two academics from two different perspectives to talk about actually what will we do now? What rules will we start to impose? All right, and what enforcement mechanisms should we impose? These are two questions actually that we intentionally did not answer in the Furman report. And so it's nice to be able to develop that and to come from these two different perspectives. And the rules we were looking at were actually based on particular principles that we'll discuss tonight about free competition, about fair trading, fairness of intermediaries, and the sovereignty of consumers and decision making. But the rules themselves try to go towards defining some of the aspects that President Mund was talking about, relating to the kinds of practices that we're most concerned about, whether it's access to data, whether it's discriminatory practices, or whether it's self-preferencing in a larger sense. And we wanted to open a debate about whether we've captured the right concepts, where we've got the right direction as well, but it's intimately linked with the enforcement mechanisms that we propose, because we believe that in this area, and digital is everywhere, but digital is also dynamic. And so as much as we were trying to provide some degree of certainty, in a sense, with respect to some of our proposals, at the same time we were recognizing that it's the enforcement mechanism that will put the flags, that will adjust and make sure that the rules are relevant. So we tried to humbly suggest that we're proposing sensible rules, reasonable rules for effective enforcement.
Would you like to add something on regarding the principles? I mean, when we commissioned this study, we didn't want a pure German or pure French or a pure British study. We want to mix the best from our tradition, so to say, the ordo-liberal part from Germany with this liberal spirit that we have on the island. And I think that the paper really, from that point of view, it goes in this direction. Can be read in that direction.
I want to Pencho whether I have to reject that notion that I'm an ordo-liberal, because sometimes that maybe I'm no longer able to enter any US academic debate or so. I don't know. But
as a German academic, I think we have to be.
Absolutely. in Konrad-Adenauer-Stiftung, I think we can live with that concept. Thanks to Philip and thanks to you, Pencho, for enabling this study. I just want to add we are now in the context of looking at the EU proposals for a new competition tool and the Digital Services Act. And when I started to think about this, with a lot of help, you got me thinking basically, what I noticed was we now need a breakthrough in all these digital platform regulation issues, because we have seen so many studies, we have read a lot of reports, etc. We have seen a lot of interesting cases, but we now need to make the next step, basically. And the second thing that I understood is, if we need the next step, we need to take it now. We cannot wait for any longer, because otherwise things will be sort of completely stuck or petrified in the digital environment. And also what Philip and I sort of found was that enforcement really matters if we want to have this breakthrough in platform regulation. So that is basically the background to our study. But what was important to us, and you mentioned that, Pencho, is that in the debate we see a lot of different rules or ideas or cases coming up, etc. But what we maybe do not see with such a clear picture is what are really the principles that we want to ensure. And this was one part of our study to discuss what is it really that we are looking for in a digital environment. And the first thing, obviously, for us is free competition. So you need contestable open markets. You need to have the chance that someone still topples the incumbent, something that we don't see in a couple of issues or in a couple of markets where some infrastructures have maybe already been built. So free competition is number one, and it's something that most people in the room, I see Andreas Mund sitting here, can agree on, that this is sort of the DNA of what we are doing. But there are basically two other principles that I think are of great importance. The first is fairness of intermediation. Platforms act as intermediaries, so they act as agents basically for both market sides that they bring together. They act as agents for consumers, and they act as representatives of suppliers whom they try to match. And whenever we have this situation, I mean, there are a lot of lawyers here in the room, if you have two clients that you're working for, you're normally conflicted, and you may abuse this power that you have to moderate both sides. And this is something where we have to ensure that platforms don't abuse this situation so that they act in a fair manner. And this is something which probably goes beyond our classic understanding of antitrust rules. So it is about fairness, which of course is an entrenched concept in EU law as well. But fairness of intermediation is the second principle. And the third principle, you have mentioned it already, Philip, is something that has been highlighted so nicely by the Facebook case of the Bundeskartellamt, namely the sovereignty of people to make their decisions in the marketplace. And this is something, Philip, you said, these are really constitutional values and constitutional principles. And I would completely agree with that. If we think of what really makes a marketplace, why are we doing this? I mean, why have I been for 20 years now? It's not because I think that I definitely need to know that this product is 2 cents cheaper than 2 years ago or so, but it is because I believe in the liberty of people to take their decisions in the marketplace. I want to express my personal economic values. I want to invest where I want to invest. I want to spend my money where I want to spend it. And I don't want to be predetermined by other people who take my decisions. And this is something that I fear that we see in the platform economy more and more, that there are operators, intermediaries, who shape our path in economic things. And this is something that I don't want to sort of put up with. And that is something that we also put into this realm. And I see this, or I think the Facebook case really sheds light on this idea, on this principle of keeping the sovereignty for individual actors to take their decisions autonomously.
I think, Andreas, like what you said, is perfectly fits into the picture of the latest decision by the Federal Supreme Court, I believe. Is there something to add regarding the principles, or we have covered them?
Let me add just one thing, because it's really just an echo of something that President Mund said. We all are amazed by the fantastic things that we get to do with these devices. This lovely genie, this lovely thing we rub and some magic comes out of it. Fantastic. Choice, etc. And we're increasingly seeing the world through the eyes of this screen, okay? But it's our world, right? They should be working in our world, okay? And so this is something that President Mund mentioned. It's wonderful to have these choices, but I get very concerned, as does Ruprecht, by the fact that, yes, we are offered wonderful things and free services and choice, but it is curated for us. Right? And yes, we are able to exercise a degree of choice, but there are so many opportunities, and we hear complaints from many companies and also from consumer groups that there are aspects where they would like to have an opportunity to show that they can compete on the merits as well. And instead, it's the platform that wins rather than the products that win. And so that's something where we really thought that our principles of free competition, fair intermediation, and the sovereignty of decision-making would really be important as a foundation for the rest of our rules.
Perfect. So we continue with, so to say, with the second pillar of your study, and those are the rules, basically. There are many rules that you have in mind. self-preferencing. We talked a lot about it, but there are many prohibition practices that we have in mind. If you need to justify some of the don'ts and do's, what would you say?
Well, I think the important step first is that we move, and this is something that is difficult for real competition lawyer, that we move the field of ex-ante regulation in the sense that we give companies certain rules that they need to adhere to. I think this is sort of the change that we are now going into, and the German legislative draft of the GWB, what's that in English again? The Act Against Restraints of Competition moves into that direction with this prominent Section 19A. Sort of giving more detailed ideas about what do we want in competition and what do we not want. And I fully endorse that. I'm very happy with that. We can probably discuss on that later. But maybe we need to take a step more. And this is sort of the first thing where competition people probably have to sort of move beyond their traditional or more traditional lines. And the rules that we devise as ex-ante rules that are in a blacklist or in a delegated act or some form of community or union document, they are of course oriented towards the principles that we've just discussed. So, for instance, interoperability, on-platform competition, things like that need to sort of secure that competition is possible. Then we want to have rules so that companies act, or intermediaries, platforms act in a fair manner, etc. And we have some of that already in the P2B regulation, as all of you will know, the platform to business regulation. But there we have transparency rules. That is to say, companies, the platforms need to declare what they do. They need to disclose certain way to the companies that are active on the platform. But we see that this is probably not enough. So if I personally, I don't know, maybe Philip, you want to add on that, but personally, I don't stick to, okay, we definitely need this provision now or this provision. I'm fine with discussing that, but I'm pretty sure that we sort of need to move one step further in making certain rules tougher than they are at present.
Exactly, and I very much love the GWB. I don't say that just because I'm in Berlin or visiting Bonn later or something like this, but this is our GWB. It's gold, white, and blue. This is our book, and I feel a bit like I'm at some book reading, if you will. So I will read out some of our rules, if you don't mind. For sovereignty, we have many, many do's, okay? Many, many things that if you are a company and you must do these things, and if you do them, you're okay. All right, so this is not the blacklist, this is the opposite. You know, platforms must offer a real choice on the use of data. This is the inherent aspect of the Facebook case at the Bundeskartellamt. Platforms must allow customers to take decisions. Platforms must give users the service they ask for and not impose mandatory terms or conditions. Platforms must give access to customer and transaction data to the suppliers involved in that transaction. Okay, these are do's. These are good things that we think the market should evolve from, and this is not something that we can provide through ex-post law enforcement after many, many years or something like that. We have many other do's in here, and we have the odd don't as well, and we try to define carefully what we mean by self-preferencing and these other points. But it's what we're so excited about, Ruprecht and I, in writing this, and we worked hard over the summer trying to come to an agreement, is hearing from everybody else what their views are on our points, which should be do's, which should be don'ts, which should be blacklist. Obviously, we allow, in some cases, objective justifications and defenses, these sorts of things. But we want to be able to start discussing that so that they're workable, so that we can get to the next aspect, which is most important to us, which is the actual enforcement.
I could live with Philip reading out the whole paper. I mean, that in such a marvelous way.
There are, of course, a couple of really interesting rules, but maybe you could comment on one specific rule, and that's the rule of openness of platforms. How would you describe it more concretely?
Openness probably has a couple of aspects to it. The one thing is openness means you need to leave or have the platform open for, or the suppliers must have the choice to sort of be on platforms. So exclusivity arrangements are something that we see critically. But obviously, openness also means open APIs, interoperability, data portability that should be ensured, so that we can really move into the field that Andreas Mund talked about earlier. Namely, you must be able to sort of have new players entering the market and being able to get either A, on the platform, that's sort of the bottleneck, the gateway aspect, or have competing platforms that maybe one day could topple sort of what's the incumbent. So I think there are a couple of aspects that relate to the question of openness, exclusivity arrangements as one pillar, and the other pillar, the openness of entering markets through or to eradicate technological barriers that may be there.
This is not particularly new for me to say this, but hashtag interoperability stimulates competition. That's all you need to know.
It's a bit long for a hashtag, though.
And it's easy to remember. It's easy to remember, yeah.
I mean, sorry if I may jump in here. I mean, Philip, you've made we draw a lot actually from the British experience with such tools, and we've seen the CMA investigations and market investigations where we have experience with sort of opening fields. I don't know whether you want to talk about that, because I found that very impressive when you told me, basically.
Well, I'll see what I can do. So what I'm trying to say here is this moves us a little bit towards the conversation about the new competition tool at the European and maybe other levels. In the CMA investigation of the banking platforms, and I was honored to be the deputy chair of that investigation when I was an official, we early on thought about remedies. We were identifying if there was a problem and a remedy. And our past practice had said maybe to solve this problem, when you have an oligopolistic market where information is quite confusing, maybe we need to order a price comparison website. We'd done things like that. The provision of more information to the market, like that. Or maybe we should have them, simplify their terms or conditions. But what it suddenly became very clear to us within a few months of the investigation was that the lazy financial platform incumbents were lazy because they didn't have any incentive whatsoever to compete, and there was no ability for new entrants, much more agile. There was no ability for them to get in to query the data that the incumbents were holding on. So we realized we were looking in the realm of a data remedy, which meant that we had to have some sort of interoperability standard agreed and forced upon them by an enforcer like the Open Banking Implementation Entity, which the CMA essentially ordered to be created and then funded. And so those kinds of things allowed finally competition to enter the market with new interesting offers. Now, I may have mentioned this last year here, and I hope I didn't, but the point is that some politicians immediately said, why didn't you just break the banks up? Forget a price comparison website. Why didn't you just break them up? Some sort of structural remedy. And we said breaking the banks up wasn't going to do anything to add competition. We just have more lazy incumbents sitting on their data. Okay, so it wasn't divorce that we wanted more engagement by the consumers and by the financial intermediaries. And anyway, our metric for success wasn't would you switch amongst an increasing number of providers. We have strong evidence in the UK that British people switch their spouse more frequently than they switch their bank. And so switching was never going to work, right? And so it wasn't so much about switching, it was more about engagement. More engagement with your incumbent bank, more asking, what are you doing for me? And that goes to the heart of our report. As Pencho nicely said in the foreword of the report, we're trying to make sure that even though the digital companies provide us with so many wonderful things, there is an aspect of, I'm afraid, digital serfdom at the consumer level, completely powerless, as well as the SME level, completely powerless. Do we want to be serfs? Or do we want the consumers to be the kings and the queens again of the marketplace? And that's what I think we're trying to move towards. It's high rhetoric, I know, but that's what's fundamentally driving some of our initiatives.
Perfect. I know many characteristics of incumbents, but now I've learned of laziness, and it really suits perfect to the picture. So now we have rules, principles, rules, and finally in enforcement. Who is going to enforce the rules? I don't believe that everybody at national level is that excited that if everything goes to the European Commission.
Oh dear, Andreas Mund is still here, so I have to watch my mouth. No, speaking of enforcement of this is a complicated matter, to be frank. So because we have at present we have several directorates at the Commission dealing with that. It's DG Comp, DG Connect, DG Grow is in the game. And then of course we have all the other actors, national actors, private actors, public authorities, etc. And if you really want to have a meaningful platform regulation, the first thing that is clear for us is we need something at the EU level, because we need the digital single market. So the EU Commission probably needs to be at the helm of all this. I'm pretty sure that we need support, or maybe support is a too diminutive word. We probably need a strong role here for national agencies as well. But we probably also need some new entities on the Commission level. We speak of an early alert unit at DG Competition that alerts us to problems in markets where we have to step in. We also have a, I always get it mix it up in my head anyway, the platform complaints panel and a platform compliance unit, where we think that platform compliance unit at DG Connect could sort of be in charge of coming up with rules and trying to enforce rules. Of course, obviously with the help of others, and we have a sort of, we propose a market investigation regime where independent panels, independent expert groups, sort of matching the British system, could more closely investigate systems. But one thing for me is very clear. We cannot do that without the national competition agencies. We cannot do that without the support of private market actors. Particularly in Germany, we have very strong sort of experience with private companies suing for unfair behavior under the Unfair Commercial Practices Act. And I think that we need something like that, a stronger role here as well. So it should really be an interplay of all these different factors, and we shouldn't be, please, European Commission, Madam Vestager, we shouldn't sort of be lost in intricacies of DG competencies with this unit doing this and that doing that. I think we really need a solution from one sort of source.
And can I just add that there's three sort of fundamental changes that need to be done, which we're almost there. One change, which I think almost everybody agrees with, is that we need to move from ex post law enforcement to some sort of supplemental, where needed, ex ante regulation. So that's quite a shift, okay? The second shift is this idea of importing a new competition tool or a market investigation regime, which, quite frankly, and perhaps to German ears is a bit scary, is identifying structural problems and remedies onto firms, onto companies, but without blame, without any finding of infringement. But you're saying this market is not working as well as it could, and therefore we are going to intervene. And I appreciate that as a very big philosophical shift. Right? And the third aspect is this idea of an interplay amongst the agencies. The agencies are cooperating very well, but there are some directorates general at the Commission which I think are probably quite siloed for various historic reasons. We strongly mandate a stronger interplay between these DGs, and our example in the book is DG Comp and DG Connect. And I'll just give you one sort of fact scenario. If we have an early alert unit, as we're proposing at DG Comp, which is looking at tipping markets, and markets can tip for perfectly legal and economic reasons, but there might be some aspect to which the market is tipping due to some unnatural practices that perhaps should have been caught by the rules, which DG Connect would be in charge of. So the early alert unit could combine and discuss with the platform compliance unit to say, hang on a second here, is something happening here where one of these players is not acting according to the rules, and there we're going to see an unnatural tip. And we might also see some complaints coming into our platform complaints unit saying, we think there is something going on here. We can't get the access to the data we used to have, or there's, our rankings have disappeared, or whatever. There's, something's happening here which we find is we'd like a decision on. And we propose a very, very fast arbitration mechanism for resolving those kinds of disputes to hopefully ensure that the markets, if they do tip, they tip naturally, but they're not inherently tipping due to some exploitative or exclusionary practice. And so again, it's a supplement to competition law, but it's trying to get ahead of some of the problems rather than just waiting and then having to expend so many resources to try to cure something that has already happened.
I think when we started the discussion regarding the study, we had some common ground. We were not questioning, do we need more stricter rules? You can call it regulation or whatever you want. And we had also common ground when it comes to the issue, we don't want new institutions. But we believe that within this frame, with a better collaboration and with more collaborative approach also with the national agencies, these new rules are applicable, so to say. I think the study offers solid ground for the legislative plans of the European Commission in the fourth quarter of this year. We are really happy that we did it, and that while many studies are simply justifying why we need further regulation. I think we are saying how we should step forward. Now I'd like to invite Andreas Mund again. Please join the discussion, and Thorsten Keserberg. I hope he's in the room, and would like to hear their view on the matter. I was making a joke with Thorsten a couple of weeks ago. I said, you don't need to be disappointed with our GVB in Germany, since our ideas, as you could see, they have already landed in Brussels. But luckily, last week or 2 weeks ago, we have the new legislation draft arrived into the parliament, and we hope that the next steps will go smoothly. You had the privilege, Thorsten, to take a look into the study a couple of days ago. What's your impression? How this concept capture into the picture of the new draft German law?
So many thanks for the invitation and the chance of being here for the second time. And I think it's really Philip has moved forward the debate with the Furman report. And I think when we talked just outside before, we said that it's maybe sometimes necessary to cast the right stone at the right time. And the Furman report did that, but left open some questions. And I think Ruprecht and Philip have now followed up with more detailed answers, as you discussed before, on substantive rules, on the institutions. And I think we are indeed happy that with the German draft legislation, as you said, we are now entering into the second half-time of the game and hope to have it adopted by beginning of next year. We are actually happy that there's always been a lot of interaction, not only in terms of enforcement between the agencies on the national level and DG Com, for example, but also conceptually between national, including German competition policy and European competition policy. And in that regard, I think we consider it a very useful approach. We think that there are common elements, as you've highlighted before, in the sense of the principles that you've outlined. And I think, as you mentioned, in particular, in our draft law, we have the provision on the platforms with paramount significance. And I think some of the don'ts that we have in this provision actually are quite similar to what the Commission is thinking about, but there is only an overlap. Of course, as you mentioned, DG Connect and DG Comp, they are thinking maybe a bit broader, also in terms of consumer protection. You've mentioned also consumer choice. So there will be probably a bit of a different approach on the European level, and it has always been the case, an intellectual, conceptual interplay. And we are just happy that the Commission has now taken the new competition tool and the Digital Services Act. And we'll, of course, have a look at what the Commission will table by the end of the year, and then see whether, for example, we might even have to look into our draft law. We always, and that's maybe my final point from a legal point of view, member states in the European Union have legally the leeway to have stricter rules than on the European level. And now we'll probably might have stricter rules in some regards on the European level with the DSA, and then we have to see. In the end, you've talked about whether enforcement at the European level or all enforcement with the Commission is better than national level. Cooperation is key, but there are indeed strong force and good arguments to say that at least some key cases have to be enforced on the European level. And I think that's something also the Bundeskartellamt, who is doing great cases and important cases, but some of the cases really should be at the European level.
Many thanks for the clear words. Dear Andreas, maybe the same question to you. Do you see all these principles that the professor are mentioning replicated in the current German approach? And maybe also the second question that Philipp raised: do we really have a problem in Germany identifying structural problems and imposing remedies without finding any abuse?
This is a bit irony of history, that we are the ones who should be against structural problems and solving structural problems. I mean, I remember times when Philip Lowe was Director General, to be a structuralist was not the best thing to hear, let's put it this way. And we were the one who had slept too long and not seen what it meant to do it more economically, the new economic approach and all this. No, I fully agree. And I think this study, it is full of excellent ideas, and it takes a very structured approach. This is what I appreciated most, because I'm constantly saying this for years. What we need is, as competition agencies, we need to have an impact. We really must change things. That's the point. And sometimes talking also to colleagues, sometimes I have the impression in Germany you say, man bekommt Angst vor der eigenen Courage. You might get fear before your own courage, because also means that you are not only operating in a legal environment, you are also operating in a political environment to a certain extent. That yet you have that courage, and that you have backing for that courage from the political side. That is extremely important. And I think everything that is in that study, at least as far as I could read it so far, is taking us into the direction of impact. How do I have an impact? And this is the same what is now happening with the German approach to the 10th Amendment. This is also about to have an impact. I mean, for a long time we had a discussion about fines, and I always said, I don't think that fines will do any better. A fine is a price for these. What will happen with fines when we see the first cases of civil claims against these kind of companies, when you have brought the first successful cases that have been brought to successful end in the last instance before court. I mean, we see what is happening in other areas, and we might see some things in this area as well. But we do not have these cases yet, these huge cases that have been brought to a successful end. So this is all about impact. This is what we do in Germany with the 10th Amendment. This is what we see with the new competition tool. And this is what we see with the Digital Services Act. This is really about changing things. A lot of don'ts, a lot of do's that Philip has mentioned before. I think, Mr. Kaiserberg, one can say we have them in the law as don'ts. you can put it either way, do or don't, but we have it as don'ts. And I see a high level of consistency with what is happening over here in Germany, what is happening in the UK. By the way, it's also ironic that Philip, coming from the UK, is so much thinking about what should happen at the EU level. That's nice thing too. But we have much consistency in terms of approaches in the UK, in Germany, at the European level. It might not be all the same, but the approach is very much alike. It's all embedded in an international or European debate, and this is very important that we all go to a certain extent in the same direction. And I think in Brussels we stand in front of a very interesting debate. This is who shall enforce what will be the role of national competition agencies with respect to the Digital Services Act and the new Competition Act. Do they want to enforce? First question. And the second question, does the EU level want them to enforce? That is a question that is not solved yet. And what will be very interesting to see is how DG Connect and DG Comp will get along, because so far I see two initiatives very much going in the same direction. And now we have, or the EU has to put that in a paper, in writing. and now it becomes more specific, and you cannot let these tools just stand beside each other. You must coordinate in a way, and maybe they should read that study. There are some ideas how to coordinate. So we have a horizontal and a vertical need for coordination in this respect, and this needs to be discussed.
I think also the market players wants to know what rules apply in the new competition tool or the ex-ante rules, and also that's another issue. But would you like to add something on?
Just a very short remark, because that's maybe the only thing. I would actually to have a bit of a debate disagree with what you've proposed. Maybe it's not the most important part, but institutionally, I think maybe you've sort of looked into the crystal ball and sort of anticipated how the power game inside the Commission will play out. So there might be indeed something of a collaboration or a split, let's say, enforcement between two DGs. That's not the most important thing, but you've talked about silos before. I think our experience and impression is that sometimes you need power silos if we talk about enforcement. For policy, it's good to have collaboration, and it's always good to have information from all kinds of sources. But if you want to go forward fast, and that's what everybody wants, I think our preference still would be to have a reform of the rules, but then give it to somebody with the competence, and to have the power silo maybe inside DG competition. But that's maybe not the most important point.
What's your comment on this? The first negative remark, yes.
I would first comment one sentence on what Andreas Munz said. I found it pretty striking that you said that impact is finally achieved with private enforcement and private damage claims. That it would be a part of it and an important part of it. So that's what I understood. Maybe that's a call to the ministry as well, so sort of to look into private damage claims again, which are pretty problematic in German courts at present, and also in other courts. That's just sort of one remark where I found that great that one of the public enforcers, of the important public enforcers, acknowledges this role, because sometimes in the past we had different experiences, or we sort of thought that public enforcers maybe do not sort of push for private enforcement in the same way as others would have it. I leave the critical remark to you, Philip.
Thank you very much. So this is going to be a slightly academic, existential sort of answer, and perhaps we'll see. So of course, I was a competition official for many years. I still make competition case decisions for some of the financial regulators and the energy regulator in the UK, and my prior would normally be leave this to the competition officials. You know, they are the ones who do the case-by-case method. They have the lawyers, the investigators, the economists, especially the remedies people who understand how to impose a remedy that goes along with the technological grain, the developments. These are sorts of things. But in this situation, sometimes we get some criticism in this debate about, oh, you're just imposing object offences again. And we have learned that there's no really place for those. There's a place only for effects-based offences. So this is not true. There are clearly things that we know are wrong, and we still have object offences in competition law. And yet the enforcement, at least when I was at the CMA and before the OFT, I was amazed at how long these cases still took. And so I still think that with respect to some of our don'ts and the enforcement of some of our do's, there is a role in some ways for learning from how the regulators act when they have an iterative interaction with these incumbents all the time. Yes, there is the risk sometimes of capture, but there's also the ability to say, look, stop this. We've caught you, and we're going to ask you to stop this right now, and there will be a fine or whatever, or we might revoke your license or whatever. And these kinds of things can focus the mind a lot quicker. So even though with respect to our general approach, while we're trying to modernize in some ways aspects of European law with respect to the platforms, we're not trying to taint or distort competition law enforcement from its main focus. We're trying to complement it with a kind of regulation that moves faster and that is based on clear evidence of obvious harms. And let's move on to say, okay, we've made this now a don't in the legislation. You've done the don't. You must stop it. and none of this, 9, 12-year investigations with full merit appeals. And that's mainly the sort of focus we have. And now then we will be able to have a debate, I'm sure for many months, I hope not many years, about the propriety of that. But the direction of travel of all of these suggestions out there around the world is in that area. Fast action, impact, and moving on before it's too late.
And I believe all this, what we're talking today, it's quite easy to implement if you wish.
Difficult to enforce.
When it comes to the legal certainty, I believe there will be many open issues. Do you have some doubts how it will function in the reality, especially when it comes 19A in Germany?
Of course, legal certainty is not easy to achieve in competition law, and of course 19A leaves question open. But this is a general problem for the time being. Everything that we do as competition agency, whatever case you tackle, you do it this way for the first time. No one has ever done it this way. There is no jurisprudence. You have no idea what the higher regional court in Düsseldorf will say. You have no idea what the Federal Supreme Court will say. And you don't have any idea what will happen in Luxembourg if ever your case goes to Luxembourg. You have to invent your theory of harm. Normally, for the first time, there is no theory of harm which has ever been enforced like this. If you look at the remedies, you have to find the right remedies for the first time. Nobody has done it this way. And nobody has ever said in jurisprudence, if you have this theory of harm, you can cure it with that remedy. And it's proportionate, and it's justified, and all these kind of stuff. So that is a general problem. 19A will make things better because you have predefined theories of harm. I think that is a huge step. Like other clarifications that we have received with the 9th Amendment of the German Competition Act, for example, the question, do we have a market before our eyes where there is no financial transaction between the platform and the consumer?
Data.
And there were judges who said, well, we could have had a long debate about that, although we have applied it like this already for many years. Yeah. So these kinds of clarifications that you go to court and say, listen, it's in the law, we do not to discuss that anymore, that is extremely helpful and helps you to bring cases through. 19A is a new provision also always produces no new questions, but personally I'm very sure that the clarity it brings, that the benefit is much bigger than the uncertainty that is produced by that new provision.
Clear words. Dustin, would you comment on this?
I think it's really a similar discussion as you've sort of filled it in your study, and that's happening on the European level. It's not so much, maybe as the Commission says, about ex-ante enforcement. So we're not talking about telecommunications regulation, something like that. We're talking about whether how to become sort of stricter on super dominant platforms than under abuse of dominance, and how to get faster. And that's something that it's not about ex ante to our taste. It's about very open standards that we used to prefer in competition law. Versus, on the other hand, more detailed rules. And here we are moving towards rules just to have more legal certainty, to be able to be stricter and faster. And that's from our perspective, the whole debate about the do's and don'ts. And so we are very eager to see the Commission's ideas and proposals on not only what they want to forbid in terms of don'ts, but how exact this will look like, whether it will be more akin to, let's say, open antitrust provisions, or whether it will be a bit more specific. So that's I think, even it sounds technical legalese, I think that's extremely important.
Many thanks. I think we should leave also the possibility for questions from the audience. I see many familiar faces, and I see over there Professor Kerber, and I'm really glad that you're with us.
Thank you so much for this great study and also the great discussion. I have a very different question. And what I found interesting is that in all the recent discussion, also in the consultations, but also in the study, and we have entirely new theoretical concepts for competition. And this is, for example, fairness. And we have also seen a lot in consultations also unequal bargaining power as a new concept, so concepts below market dominance. So in that respect, I see a lot of new concepts also which go beyond the traditional concepts that we are using in competition law. Now my question is, it is hard for me to see how economists now really fill these kind of concepts. So I'm an economist. Everybody who knows me knows that I'm also critical to my fellow economists and try to be open-minded, but I'm still asking myself if we are using more here now fairness, for example, in competition cases. How do we fill this? What kind of economic concepts can we fill this? And so how does economics come into this new world? Because this goes really beyond what we are traditionally doing in competition economics.
Shall I try? Okay,
Try,
so I will readily admit that in the English language, as a competition official, I would refer to fairness as an F word. No laughter, okay. It's not a word we like to use except when we're describing why we've done a case and what we hope to see it change in the marketplace. It's not an operational guiding principle of identifying whether or not there's been a breach of the law, or indeed, as you say, whether the economic evidence shows that there's a problem or not. But I think the concept, beneath fairness, this fairness concept that we're introducing is this idea of fair trading on the platform. Clear areas where there's some sort of exclusionary conduct on the platform, not letting somebody in. These kinds of things can be identified. But also, we need your help as economists to identify another aspect of fairness you mentioned, which is the degree of economic dependency. As President Munt has mentioned earlier, the relative market power differentials. This is something which economics can help us with. And also, unavoidability of trading partners. All of these kind of have fairness concepts in them, but the point is that we're not making sort of fairness. What is fair to you, what is fair to me, is obviously something that will differ by subjectivity. But we're making that sort of the direction with respect to the fairness on the platforms. And I think there's a great area for not necessarily completely new economics, because I wouldn't want our proposals to be seen as a way of creating a whole new industry of economists and lawyers identifying whether there's regulatory failure or not and defining what self-preferencing means and things like that. But with respect to the unavoidability of a trading partner, economic dependency, whether or not you've done something that seems clearly unfair by our rules, so that we have said you've pushed somebody off the platform, and the degree to which that might be a harm, I think there's all sorts of aspects where even traditional economics can play a hugely informative role.
President Munt would like to comment?
Not really a comment, but Mr. Kerber, maybe the pendulum is swinging back a little bit. Huh? I mean, it's been a more economic approach for a decade, and now it seems the time of the lawyers is back. I mean, if you should listen to Philip and others who speak of structural preconditions for functioning competition. Well, it's your task now to find a tablet for making that an economic theory. No, but I agree with what Philip has said. Of course, we have more per se regulation now. We also have, with 19A, a certain ex-ante regulation, because we can intervene in markets in the future where the incumbent or the company with a paramount significance for competition across market, we can intervene in markets where this incumbent is not dominant yet. And this is for me, this is a clear regulative approach, but still in a spirit and rooted in competition law. And this is where it belongs from my perspective. We have kind of predefined theories of harm, but I still believe the identification that a certain behavior is really fulfilling this theory of harm. I think that is still, in many cases, an economic task to look at. And by the way, we still do merger control, so don't worry, we still need you.
I see Oshrit over there, the co-author of the paper regarding privacy and competition with Professor Michal Dahl. Please.
Thank you for the introduction. I actually have two questions. I hope you will have time for both of them. One is more of the view that you guys have, and I think I'm picking up a little bit on the question that someone else asked before. When digital giants, that you already discussed a lot about regulating them, using privacy protection acts like GDPR as a spin for anti-competitive acts. And I guess we have plenty of examples, but the iGDPR that recently was announced by Apple is a major one, I think. I would love to hear the view whether you actively act upon it, or what's your general view on that? This would be the first question. The second is really general, and I would love to know how do you refer to economies or markets that integrate self-regulation program, if it's something that is even considered while you're regulating markets on competition, privacy, innovation, etc.?
I don't want to answer the second question, but maybe...
Shall I try the second while people are thinking of the answer for the first? So the second, I mean, and you can tell me later if I've just avoided your question. An important aspect of trying to create do's and don'ts, for me, is to try to build in a culture of compliance within a company. And that could include some degree of self-regulation. Now, before everybody bursts into laughter at the idea that these companies would ever regulate themselves, obviously this requires regulation to force it into the company. And in here, I mentioned that we're going to hear a little bit later tonight from some in-house lawyers. And I actually believe, maybe I'm still a young, naive person, I'm not that young though, and maybe I'm not that naive, that sometimes the first line of defense is actually the in-house lawyers. And if they have some clear guidance from the Bundeskartellamt or the European Commission or from some regulation, that this is a do, okay, this is a don't, stay away. Even though in the creation of that do's and don'ts, there will have been some sort of huge debate about, are we over-enforcing, are we over-intervening, are we chilling some sort of innovation or competition? But the thing is, that is an idea where you can give them that clarity and maybe they can actually help. Now, some people would say, no, they're just acting in their company's interests. But I think there is an aspect where we shouldn't automatically dismiss self-regulation completely, because some of these companies are finally waking up to the fact that this is having, a tide is coming. Last year here I said winter is coming, like that, and instead it was a pandemic that was coming. But, it was a different kind of change. But the thing is that, I'll finish with this, I'm not saying we leave this to the companies to work this out, not at all. That's not going to happen anyway. Regulation is coming. I am very concerned that if people don't look at some of our suggestions and think actually they are kind of reasonable, they are kind of sensible, if they just spend their time fighting this then, and nothing happens with respect to the reasonable suggestions, then you will see other bodies much more powerful than competition authorities come in and clear the decks with some certain particular rules or initiatives that might be really harmful. And I'm on record as saying that the most anti-competitive things I've ever seen in my life are things that governments have done, not that cartels have done. And so I really do feel that there's an opportunity for a discussion back and forth, with the regulated bodies, and try to internalize into them the reason that they have to change their conduct, maybe have to change their entire business model sometimes. Some of these models are extremely toxic and have a range of negative externalities that don't necessarily even touch on competition, but touch on actual harms to democracy or to people's upbringing. But we're just trying to see what can competition and regulation do in this space. And maybe I've spent so much time talking that we've all forgotten your first question.
Always pleasure to listening to you. Would like to comment, Austin, something or?
Well, you gave us the time to think about the first question as well, but maybe on the second, maybe we should compare how old we are, because you said young and naive and an age. And to be frank, I personally, I don't believe in self-regulation in that area, because it's just against the self-interest of companies. Maybe there is space if we move on, if you have cases where you need, where you move on into data interoperability, things like that, where you need technical codes for what kind of data should be put forward to actors, things like that. But in terms of really the first step, the in-house lawyers, I'm not sure whether they look into self-regulation codes, but into what hard enforcement afterwards would actually be the kind of the boundary. And with regard to the first, I'm not quite sure whether I really got it completely, what you asked, if the question was that GDPR and, let's say, data protection and, for example, differential data protection can be also barrier to entry and could be an instrument to sort of game the competition, then, well, yes, could be. That's something that also, for example, IP or other law, legal instrument can be. So the relation is, I think, super intricate, and it really depends on the case, as, for example, in the Facebook case. So I can't come up with a good answer.
But just very briefly, maybe. I mean, self-regulation is something positive to watch, but personally, I believe it's always better to have a proceeding in the backhand, to really, in order to really fix it. Always, sometimes when we come to commitment decisions by companies, I'm wondering if we haven't gone far enough, because if they agree, you sometimes have the sentiment maybe you haven't hit the point. So that is a feeling that you might have in some proceedings. With GDPR. For me, GDPR has always been Janusköpfig, or how do you say that in English? It has two coins, two sides of a coin. On the one hand, it's a great piece of work. We have tried to make use of it, also in the Facebook case, because it sets a standard. You know the theory of harm that is behind it. On the other side, what we also see is GDPR, in our experience, and we have already discussed that, very much helps the big ones. Because they say, come to me. We can organize it. If you come to me, you are legal. You are in a legal space. You do it right because we do it right. And I'm not saying this is a huge competition problem, but it is a problem. And this is something that we observe from time to time. So GDPR, again, a great piece of work, a standard, to a certain extent, even a world standard, but it has its pitfalls, of course, if you look into competition issues, that is so.
We'll have similar topics in the first and second and third session, so please be patient. There will be opportunities for further questions. Now we have to finish the discussion. I really like the title of the book, Restoring the Balanced Digital Competition. Maybe that would be really my final question to you, maybe with a couple of remarks. Some politicians sometimes have too high expectations when it comes to modernizing the competition rules and what effects will be at the end of the day. What's your thinking on this? Are we going to restore the competition if we really go this way, and what can we expect in near future? Maybe starting with the authors and then the President Mund and Thorsten.
I tend to say that competition law is just a tiny bit of what we need to do now. I mean, we're discussing this, obviously competition, people always think of competition, but obviously we are also discussing this from a viewpoint of economic policy and of a sort of systemic competition with, say, companies from China and also companies from the US. And I think that it is absolutely normal to discuss it from this point as well. And here I see politicians sort of in the need to do much more than reforming competition policies. Andreas Mund and Margrethe Vestager and their teams are fantastic and great, and they do a lot for free competition. But if our companies, industrial companies, whatever companies, really want to succeed, we probably need much more efforts from other people in, say, government or legislation, etc. We need digital infrastructure in the EU that is better. We need more private equity, venture capital. We need more sort of entrepreneurial culture, more education in this regard, etc., etc., etc. And probably Corona has all shed a good light on where we have certain deficits in this regard. And so I would always be a bit modest with what we are doing here. What we are trying to preserve is sort of some fundamentals of how we do business, of how people can engage in markets, but for sort of really coming into a digital economy that is sort of, as you put it before, not shaping us, but that we are shaping, we need to do much more in Europe, and that is a task not really for competition agencies, and that's something that I would always stress.
Many thanks, Ruprecht.
And within the competition bubble itself, when we talk about restoring balance, what I believe Ruprecht and I and others are talking about is all we're trying to do is note that you have great power, some of these platforms and aggregators. And with great power, somebody once told Spider-Man, comes great responsibility. And we are trying to impose on you, through the do's and the don'ts, the responsibilities, to therefore restore the balance. A politician who wants a quick win, who wants a European cloud company or whatever, you know, that's not going to happen through some of our rules, okay? We're trying to put these rules in place to go with the grain of technological developments, to, in a sense, restore, as Ruprecht said, some of the fundamental values of our democracy and our economic foundation in the digital world as well, which is openness, interoperability, the idea that you can enter and leave quickly, these kinds of things. You will have sort of some fair treatment on a platform. These kinds of things are really strong constitutional values. We're just trying to reintroduce them because I think they've largely been forgotten. Right? And finally, we're just trying to say, actually, that in the process, we hope to see more competitive outcomes. Right? So yes, many politicians may well be saying this is not enough, we need to do more. That's what I'm afraid of. I don't want them to do something strong and interventionist, and that's why I think that our approach, frankly and humbly, is measured, you know, and is not some drastic, scary intervention that the sky will fall apart and all of these companies will go out of business because of Ruprecht Podson and Philip Marsden, you know, like that, or the stronger regulators and agencies who might do something with these suggestions. It won't. All we're trying to do is add to the great power some great responsibility and thereby restore the balance.
And we have this discussion already at least 3-4 years intensively, and to rephrase you, now it's time to legislate. So I'm glad that Thorsten is with us. Thorsten, are we going to restore the balance, the digital competition, with the new act in Germany?
As to have said before, and Ruprecht, it's a tiny piece. It's a beginning, and we'll see lots of other things. I mean, one other sentence, maybe not with great power comes great responsibility, is from another area, is follow the money. I mean, make those companies pay taxes, make them pay content providers and artists. And competition is one part of an agenda, and let's see whether maybe we're going to see more structural changes, separation of certain activities in the future. I think we are really now, if you look on the scale, the last 2 years we discussed whether we have stricter enforcement, interpretation of European competition policy. Now we have the European proposals, we have German other proposals, and this will continue. And as you said, it's one piece of many things that will probably and should actually happen.
Many things. When it comes to separation, you have already ordered a certain kind of separation, but obviously it will come something more in the future. The same question to you, President Mund. Are we going to restore the competition also thanks to your support in your activities?
Well, I hope in the very end we will do it right. I mean, you will all watch and we have to do. That's a different position. Just 2 messages. One is we should not forget what we have done so far. We are not completely reinventing the wheel. I mean, we had a 9th amendment of the law, and we have benefited a lot from this. And there are cases out there that have the quality to really go to the heart. I don't want to bore you with a Facebook case, but this case really goes to the heart, because for me, it's one of the first cases that really goes to the root of dominance. And we will see what we can make out of this. And so we have done things already. We will be able to do them easier now, but we have done things already. Second message, this is only the economic part of the big picture. Not that the economic part is not important, it's a very important part, but it's only a part. And if you think about the fact that in the Philippines, there are thousands of people sitting in front of a screen watching extreme violence, extreme porn with kids and everything, to take a quick decision if that has to be removed from Facebook, YouTube or whatever or not. If I would present that to you in Germany as a business case and tell you, look, I'm doing this social network, but it has side effects. And this is one of the side effects, that thousands of people will have to sit in front of the screen in Germany, having to watch this, all in psychological treatment afterwards. Then you know what I'm talking about, and then you know that economics is really a part of it. We have done nothing with regard to regulation, with regard to our kids who can consume all this in the internet. We have no real means against hate speech, against mobbing, and I'm not so sure that we are really able to protect the democratic build-up of the minds of the people if we really are able to control that in the social media. So again, this is an important part, but it is a debate that is of extreme importance for the whole society. And there are many articles out there just right now who ask, is our brain, are our minds really fit for what is happening here, for all these social media issues? So we really must go further. But this is an important step. Again, I don't want to minimize it. I don't want to say it's too little. But we have to go much further, and you have to do much, much more.
Many thanks for your wonderful remarks. As you said, this is the first step. You said also that we have really wonderful cases already done. And now I'm remembering that we discussed last year the Amazon case and all the commitments. I'm really looking forward to what happened in the meantime and how the whole issue develops. Maybe we'll see something at European level. The study is here. Please enjoy the lecture. It was really great to listen to you, and many thanks for your questions. Now the time has come for a small break. Please be careful and respect the corona rules, and we continue like in 10 minutes. Many thanks. Thank you. Okay, so we continue the discussion. We have the first session after the presentation of the study Restoring the Balanced Digital Competition, and now we're going into concrete details of the proposals of the European Commission. And this will be the first digital try, so to say, because not everybody could make it to travel to Berlin. And I'm also happy that I see Paul, Louis Crofts also with us, and Oli from Google. We have with us Wolfgang from Deutsche Telekom, the senior vice president. We have Andreas Schwab, the representative of the EPP in the European Parliament. And of course, we have Rebecca in charge of privacy and competition issues in the biggest digital association, so to say, in Germany. I'm right. So these ex-ante initiatives arises from a range of concerns, which, according to the Commission, may lead to risk of reduced social gains from innovation and large-scale unfair trading practices. We have three options on the table by the Commission. They're quite clear. What do they want to achieve in the coming period? So one option was simply to revise the B2B regulation, although this regulation is almost already went into effect, so to say, a couple of weeks ago. Then the second option was collecting of data from large platforms by dedicated regulatory body. And these options would not include any power to impose remedies. And the third option has two supplemented variations, so to say, for gatekeepers, where gatekeepers would be identified by yet to be agreed set of criteria. And the two sub-options are blacklisting or tailor-made remedies. So we have a clear picture where what are the possible options on the table, and my first question probably goes to Wolfgang. I remember while I was working for Deutsche Telekom, even 2012, that you were raising the issue of level playing field in Europe. As we could see, how many years later we have finally reached the momentum, and we have some concrete options. What's your comment on this, and do we really have enforcement gap?
Well, I think if we look at what has been discussed in a previous panel, it is absolutely clear that we do have this gap. And as you know, I'm coming from antitrust competition law, and I'm doing this now for 27 years. And if I look at all the attempts of competition authorities to really handle these issues we are looking at only with competition law, I have to say this will not work in the future. And if you then go into more of the details and look also at what we here heard on the economic side of these markets, I mean, we have already a lot of experience with regulating network effects, and most of the detrimental effects we are observing are stemming from network effects. We have a lot of experience in keeping innovation alive, but withdrawing the power of single companies regulating entire ecosystems. What I'm talking about? I mean, I'm talking about energy regulation. I'm talking about the regulation our companies are subject to. And if you then look at what is the proposal here, both from the EU Commission, but also in this extremely well-written study. I think this is one of the first studies I have read, and observing this subject matter now, as you said, for a long time, which really goes into the subject heart of the what to do and how to regulate. If you then look at these issues the study also raises, you can say it's very, very simple in a way, because the basic principles in order to get grip on network effects are also addressed in this study. It's non-discrimination, it's access, it's interoperability. And then you can derive a lot of other proposals, what is to-dos and not to-dos, from that. So I think the idea of really now having a blacklist, as it is called, and having a framework regulation above with some very basic principles, and a lot of discretion on the side of the enforcing agencies is a good one. Because I don't believe that any of these companies will ever go to rules that are really favoring the market. I mean, this self-regulation is, to me, a pretext to avoid enforcement and to delay all legislation. And we can easily go also into examples, but I stop for the moment here.
Okay, many thanks. The whole discussion must go through the European Parliament. I believe and I hope that all these proposals were made in close collaboration with the European Parliament, and you are the strong protagonist of these new approaches by the European Commission. I believe you support this move into more strict rules when it comes to platform economy and new enforcement rules. What's your perception on this? How do you see the need for new competition tools, the new ex-ante tool at European level?
Well, thank you so much for this invitation. I think this is a great conference, and you have been asking at the beginning that there are 3 ways to do it, and the most likely way is for sure to focus on the biggest part of the problems, which are the gatekeepers. But I would like to avoid very common behavior at the time now, that we only speak badly about these companies. I think we have to admit they have brought a very high level of innovation.
Indeed.
And they are great companies. But we have to see that they are shareholder driven. And as there are only, in brackets, only competition rules, they know that they can try to work out tools and strategies, as you have called it for the conference, that the winner takes it all. And that is definitely not our view how markets should work. Now, it's true, because you have been asking about the 3 options, it's true that there are smaller players at the moment that could also become big players and could also try to be the winner that takes it all. And we want to avoid that. But we also have to make sure that those who have already taken large parts of the market can be better framed. And for that, we haven't found any clear solution. Since the European Commission has started procedures against these companies that I won't name, they have not suffered. They have been getting stronger. So I think these companies are too strong for a system, for an ecosystem where innovation is the key driver for the market, where service is the key driver. It has become a market where market size and company size is driving, and that's not our point of view how markets should operate. And I would like to tell you that when I was some years ago in France at the Conseil d'État for a similar discussion, I was impressed how the French have explained me why the German approach to competition policy has a very strong historical root, and we have fought against the big companies in Germany after the Second World War because we didn't want to have any more oligopolies that not only destroy markets but also political approaches. And we should be very careful repeating stuff that has been done in the past, but I still believe that innovation And incentives for people to work hard to have a success is much easier and much fairer devised in a country if you have SMEs and small companies instead of one or two big companies. So it's also in a certain way a genetic reflection in the CDU to make sure that the market is as large as possible and the companies are not too big. Therefore, I think we have to focus on gatekeepers in a way which allows them to operate also fairly in the future, because they have done enormous innovations. And that's because we are now delaying that and delaying it and delaying it. It's getting bad because the left is now going against these companies for other reasons as well, apparently for tax issues, even if the tax rules are done by the member states. It's not the companies who misuse, it's the member states who are not managing this. So there is plenty of questions around, and I think we should also help these companies in a certain way to be competitive, to remain there, but with a better ruling that they can also be better, explained to the shareholders that drive their strategies to a large extent.
But you have heard also Philip Marsden saying maybe they should change also their business model, and that won't be an easy issue, I believe. From the point of view of a biggest digital association, do you see any enforcement gap, Rebecca?
I think we have to differentiate between a law perspective and policy perspective when answering that question, because we do have competition rules that are against unfair competition and misuse of power, of course, and they are enforced. What we do see is that the procedures take incredibly long, and that seems to be an issue. So I think it is great that this is addressed in the recent proposals, in the DSA, so in the Digital Service Act, and in the NCT as well, so the new competition tool. We do have to be careful, I guess, with regard to how to speed the process up, because if it tips the balance in a way that we do speed the process up, but on the other hand we lose due process, then I think that's not an outcome we do want. So I would say we need to address that issue, of course, and what we also have to look at is the policy agenda that is behind the apparent enforcement gap, if you want to put it that way. Because I think what we all want, from all the different perspectives that are in this room and in this discussion we have had for quite a few years now, is we want to enable German and European companies to grow. We want them to be competitive to these large platforms, whether they are gatekeepers or whether they are just large. And what we do see in the current proposals, especially on the European level, is that they seem to be targeted at a few companies, but not really considering all, maybe the ripple effect that new competition rules might have for smaller platforms as well. So I think especially addressing the first policy option, so making or revising the P2B regulation could be an issue here, because it's quite horizontal, so it's addressing all the platforms, so it would be new rules for all the platforms, and I don't really think that would close any enforcement gap there is. What we have been discussing also with regards to enforcement is whether we really need new rules and new prohibitions for maybe gatekeepers. What the EU Commission failed to do until now, and I really hope that they will deliver on this, is concrete definitions and concrete, factors that make a gatekeeper. Because if the definition is too broad, then of course we're regulating companies that we really didn't want to address. We saw this with the GDPR. I think it was also targeted at some companies, at least with regards to some articles in there. And we are seeing how that turned out. So.
So let's continue with our first digital try with Paul. I really enjoyed reading his report for the Dutch government, also named gatekeeper platform regulations. And there is one interesting aspect in your report when it comes to effectiveness and efficiency of the new rules. How do you consider this proposal of the European Commission, Paul?
In the panel, and let me dive right into also what we found in the report. So it was a joint work with my fellow economist Nicolai van Gorp, with whom I cooperate a lot on digital platforms. So the ministry asked us to figure out what is a digital gatekeeper and what type of regulation would be necessary. So we wrote an independent report. It hasn't been followed up in full extent because the ministry has its own considerations. And I understand that they have considerations because there is this big unease about the size of digital platforms and the sort of power imbalance, I guess. But what we looked at in particular was, does it make sense or is it possible to define a digital gatekeeper? Because that would be the basis for regulation. And our viewpoint is that, well, the main problem, at least if you restrict yourself to competition issues, is that a gatekeeper can be a platform that applies discriminatory practices with an anti-competitive impact. And what we then derive is that you don't really have to define what a gatekeeper is, because we just are thinking about digital platforms, whatever they are doing. And if a digital platform is vertically integrated and if it discriminates, then there may be a problem. And the problem is due to the fact that the anti-competitive effects may outweigh the efficiency motives or the pro-competitive motives that may be present. And I think this is what matters. So it's not so much the size of a company in itself. Well, that may be problematic for other reasons, but if you just think about competition issues, then it's not the absolute size, but the relative importance of a platform to behave in a dominant way and abuse its position with an overall anti-competitive impact. And this provides some clues regarding to how you can work with this from a policy perspective. So of course you can work with an ex-ante instrument, but you may also supplement competition law with guidelines describing how competition authorities can infer dominance from market behavior, in particular from discrimination by a vertical integrated platform. Because if a vertically integrated platform discriminates, then by implication it is dominant. So that's sort of the key idea that we develop and that we then use to compare the effectiveness of ex-ante regulation with a competition policy approach supplemented with guidelines that allow for quick intervention.
Many thanks, Paul. Let's continue with Oli. Oli, are you with us? Hopefully also from Brussels. Oli Bettel.
I am. Can you hear me? Can you see me?
We can listening to you, not watching you here in the room, but we can listening to you quite well.
Okay. Okay.
Strange question. How do you feel as a gatekeeper?
That's a very good question. It's a good thing you can't see the video as I leap.
Now we see you, so it's even the full effect is in the room.
Yeah, good. That's good. Well, thank you very much. I'm glad the video came as you asked that question, Pencho. Thank you everyone for having me this evening. It's a pleasure to be here. I'm actually in London. How do we feel as a gatekeeper? In my company, in my part of the company, optimistic, which is going to sound like a strange thing to say, I think, this evening, given some of the commentary. Although I found this evening very interesting and very constructive in turn, I must say. But optimistic, I think, for a number of reasons. I think that one of the things that strikes us, I mean, we can talk about, my fellow panelists here and others this evening have talked a lot about, I don't need to talk about the value the value creation of technology firms, the dynamism of the market. Those things have already been mentioned well, I think, by my colleagues. Nor do I really need to get into the details of some of the enforcement action that you're already seeing around gatekeeper companies and how this sort of works in parallel, complements the discussion that we're having here today. I think those points have also been very well made. I do think those are important connected ideas to the notion of gatekeeper legislation. But I feel optimistic for this reason, because as a company that is often invited to talk on these panels and is often referenced in these well-written, rigorous documents that we're discussing tonight and in other contexts, it is patently obvious that there is a good and constructive motivation behind the discussion around how we can innovate in legislation. You cannot be working, in my view, for a company that presents itself as an innovator, a value creator, a fast-moving, dynamic company, and not expect the rules to also be dynamic and innovative and fast-moving. And I think that's where my optimism comes from, is that this is an effort for the rules to develop alongside these fast-moving technologies. I do think there are a couple of observations that we have, as you said, as one of the companies that's often referenced here. I think there are sort of two clusters of questions that we discuss within the company when thinking about ex-ante legislation, regulation. The first is, and this is really not for us, to be clear, this is not a question for Google to answer, but what is the policy objective? What ultimately is the vision for these new rules? We hear different variants of that. I think that's an important debate. I think that the paper that Philip and Rupert have just published is an important practical step forward there, and it asks a series of questions that we have been wanting to hear and to discuss. You know, how do we want these markets to operate? Where are the trade-offs between innovation and legislation? Where should we draw the line between the idea of curation and misleading consumers? We need to move that debate forward, and I think there are a lot of very interesting questions that are now being answered, particularly in this paper that we've discussed this evening. The other area, and then I'll get off the mic. The other area where there are interesting questions for us within Google are around the process, the procedural questions that are now, again, in a very pragmatic and constructive way, I believe, in this paper being discussed. What kinds of tools are we going to now give agencies to ask the right kinds of questions of me and my team? You know, what kinds of data analytics, what kinds of research organizations do we need to have within the institutions to be able to ask the right questions and analyze the answers quickly and effectively? How does that translate into practical guidance? Just very quickly, Pencho, on this. I think that, just to pick up this point on self-regulation from my perspective, limited as that is something of a spectrum. I take the point well. I think it's very reasonable to be somewhat cynical when you think about the notion of self-regulation writ large. If self-regulation is a justification for not doing anything in the space, I share that cynicism. I understand that reaction. The version of self-regulation that I think we should be cognizant of as we think about how we discuss what these rules ought to look like is this. Within the in-house function, we self-regulate on a day-to-day basis. We look at the rules, we look at the guidance, and we apply that to the product decisions that we see. And it's important for that to feature and I think to contribute to the debate, because we can be much closer to the product decisions on my team. We are closer to those decisions to launch, to iterate, to change products. And I think self-regulation, effective self-regulation, is where you marry that kind of on-the-ground guidance to engineers with tools that give you a clear sense of the policy objective and practical and pragmatic guidance. And that, I think, is the form of self-regulation that I think is possible in this environment. That's too much. Thank you, Pencho.
Many thanks. So let's go into this direction, fairness of process and fairness of outcome. That the outcome could be unfair, but that's not the objective of the competition law, so to say, at the end of the day. What do we want to achieve by this new possible regulatory step at European level?
Well, I could give in a very recent example. I had the honor in my company to co-lead the development of the Corona Warn app. And if you look at the small history of Corona warning apps in Europe, you see a striking example how big the market power of Google and Apple is, and how small even the power of countries like France is. Because what happened in the beginning of this development, the direction was, let's have a centralized app which is also interoperable throughout Europe, and let's develop something which is open source, and compatible with GDPR. So what happened? Everybody started developing. In Germany, I think there were 20 companies developing in parallel. In between, Google and Apple teamed up and told everybody, by the way, we are controlling the Bluetooth application. And the Bluetooth application was the thing where you can measure the distance and also the time you're sitting. And that's the very essence of a Corona warning app in the beginning, this measurement. And by the way, we do not accept centralized apps. The French government said, well, we don't care. We want to have a centralized app. The API published was of no value to anybody who was developing this centralized app. They had to do extra coding for the Bluetooth. And that's the very heart of the failure of the French app, which doesn't work, which takes away most of the power in the phone. So everybody who was trying to develop an app was then relying on Google and Apple. And then the game started. You had to address them whether you could measure within 15 minutes how many times in order to get a correct measurement. That needed, I think, at least in Germany, every week escalations on CEO level, even with the Chancellor's office. Otherwise, it wouldn't have worked. If you then look what they provided for as an API, and which was used then in Switzerland as the first measurement, the accuracy of that API was 20%. So 80% of all measurements were crap. I mean, that's nothing you can provide to a German customers. So we were in a situation 2 weeks before launching, what are we doing? And then we set up our own laboratories, calibration, had exactly coding they didn't want. We escalated again. In the end, we had 90% accuracy. Funny thing is, shortly after, they took it and they're now selling it in the US. Yeah? Same system. It's developed by Fraunhofer and SAP and Deutsche Telekom. And I mean, if I look at this, and no company and no government has really the power to force them and to make this easy. And if you then talk to German startup communities about their behavior in the app stores, I mean, there were plenty of cases before the last Football World Championship where we had very nice apps, which were just delayed until after the whole championship took place. If you then ask the guys, why didn't you complain? Well, we have other apps running and we don't risk any complaint. And Brussels does not enforce. I think we need, for such reasons, we need ex-ante regulation, we need clear rules for operating systems, we need clear rules for other systems, because also I don't believe in the dynamic part. I mean, if you have a market share of 90% in one market, like search, for 20 years, what is dynamic in this market? Sorry to say, yeah, that's a stable monopoly. And we are facing this in other parts, and that's why I'm believing against my own beliefs on regulation, because I always believed in competition law instead of regulation, that only ex-ante regulation can help here.
Only ex-ante regulation can help. Andreas, the same question to you. What do we want really to achieve? I believe the pressure also on the member of parliament is really high, because the people are really expecting some new wind in the digital sphere in Europe. They are asking why do we have such a strong monopoly position in many couple of fields, and they expect that you should correct this market failure, but by some new rules. What do we want to achieve? Fairness of outcome or fairness of process?
I think we want to achieve fairness of the outcome and of the process. But we don't want to create problems for innovation. And I think that was the point of Bitkom, saying that if we go for too much regulation...
You believe that this kind of regulation maybe could affect also the innovation of Google one day?
Honestly speaking, I use Google every day, but I'm not concerned that much about their level of innovation. I rather care about the small newcomers in the market that want to look for their chance and have one good idea and are too much dependent on a few companies, on everything. And we should not now go into too many of the details. I think there are some examples that can show to you that these companies are extremely big, they look extremely strong, but maybe they are not that convinced themselves about their strengths. I'm always wondering, I think in these new times, it's much more transparent, everything. I think when an old automotive company was 25 years ago changing the supply chain, there were some specialists doubting, but it's not open to the public at the time. Now it's open to the public. So if you take your phone, and everyone has a phone nowadays, more or less, you see exactly the uncompetitive behavior that is there. I don't understand why a company that is so innovative needs to spend 2 billion euros every year just to be on the main screen with the search function. I don't really understand that. If the search is as good as it's told, I wouldn't spend that money for it. I don't understand how it can be that you replace the music function on the phone that has already been in another app, and you integrate the app into yours and you sell it as yours. I mean, there is so much incoherence that is showing that maybe the strength is not as strong as a lot of people believe. That's a problem. But we have also another problem. Our public, and I think my predecessor was explaining that very well, the problem is that the public is overly concerned with data protection and privacy. And these new companies, they are not that so new anymore, but these companies have a much more modern approach to convince people to give up their data. I think people know that they have already given their data to them, but now with the rules that we have done, people are rather reluctant to share the data with other companies. And that's a problem, which is not the problem of these companies, of the big ones. It's the problem of our public and the misconception they have. And I think we have to work out several things. What we want to have is more fairness, a level playing field where newcomers into the market have a real chance, not only to be economically independent and to have a certain choice with what partner they want to cooperate, but also to win over with their product in a market. And that, for the moment, is not possible.
Many thanks also for the great examples, supporting the thesis that we need ex-ante clear rules in this respect. Rebecca, Andreas also mentioned we have like constant situation on the market. We have stable market share also on many different fields. How do you consider this as a market failure that must be corrected, or maybe because of the specifics of the network economy, we should simply get over and focus on different issues?
I think the examples that have been raised just now by you both are excellent examples to show that we have a new kind of market power nowadays. The share platforms can have in one market or in several markets if they're integrated is something we haven't seen before. And I think that we do also see that it isn't maybe properly addressed in the competition law we have now. What we also see, and that coming back to your question whether we need procedural fairness or fairness of outcome, is that I do agree that we need both. We do need process to be fair. We do need competition law as a law itself to work properly, to be enforced properly. But we also need a fairness of of outcome. And I think that is something competition law itself cannot achieve nowadays, because the law needs to be as integrated as the company, as the companies it's trying to address. And I think we have to accept the fact that we do need like a holistic approach to the law, and to really intertwine all the regulatory efforts here. So with the GDPR, with the new competition law, with special telco regulation that is also addressing the platforms soon with the ECC. And I think that's a new approach we have to take. I think that is also something that Ruprecht mentioned in an article he recently published, that we need some boldness with regards to our regulatory approaches. And we do really need to learn from what the GDPR didn't achieve. We can't make the same mistakes twice. And I think that's a clear message to you, Andreas, and to everyone in Brussels, that we saw great regulation coming with the GDPR. It's a great piece of work, but it's also a piece of work. And we can't do that twice. And I think overregulation in a competition law context would stifle innovation in the end. Maybe it will also stifle Google's innovation. I don't know, maybe even innovation in other companies. Well, it would definitely be a hurdle for other companies to thrive in Europe. And I think that's the policy aim we really want to achieve here.
That's my favorite part, among others, in the study of Ruprecht and Philip, where they really call upon the experiences with the GDPR in the actual context. Interestingly, I'm not alone in this moderation. I have my co-moderator in Brussels. Unfortunately, Louis couldn't make it, and really enjoys his regular tweets on competition matters every day. If I ask you to support me, Louis, what questions or comments you have for our speakers?
Hi, can you hear me? Can you hear me?
Yeah.
Can you see me? Excellent. Yeah, thank you very much. I'm sorry I can't be there, and I've supplied some questions to Pencho, who's asked them with infinitely more charm and less aggression than I would have done if I was in the room. So thanks for that. The question which is sort of on my mind when I look at these, some leaks have been going around in the last couple of days on this gatekeeper legislation, is it seems very much to target GAFA, the big four, and we've talked about that. And Philip Marsden earlier talked about changing business models. But it seems to me that the only thing that unites these companies is they're just really, really big. They've got completely different business models, from monetized through data, or monetized through advertising, or monetized through devices, or retail markups, or whatever. And that would be, business model would be a very big part of the analysis in a competition case. But it seems here that the business models are all lumped together in this legislation. I was just wondering if anyone on the panel thought that the differing business models should play a role. They usually would play a big role in how we would remedy conduct, and how the outcome we would seek from a prohibition. How do we match the different business models together in a piece of legislation which applies so broadly?
Really difficult question. Who would like to answer? Also, I mean, it's common for all these companies that they don't have common business model. They rely their business model on data to a significant extent. But of course, there are some common grounds. But you're definitely right. We try to frame a new framework, but to address basically different business models. Yeah.
I think that's an excellent point, because platforms do work differently, and they have different business models, and regulation should account for that. But I think that is also why we're talking so much about them in a competition law context, because that's where we address certain behaviors. And regardless of what the concrete business model is, if you're applying certain behaviors in the market, then we can address that with competition law. So I think it's a good starting point there. But we do have to keep in mind that they do work differently, and there are different mechanisms at place, and there are large dependencies also from other markets and following markets, which brings me back to the point that over-regulation might stifle innovation, but I already said that.
Okay, thanks. Wolfgang, please.
Yeah, I mean, there's one thing which is also common to GAFA, or maybe Fangman, and that they already took the market. The winner takes it all, at least in big parts of the markets they operate. When I started, I was mentioning some principles how to regulate network effects. Why did they take the market? It was due to network effects. It's usually a two-sided market, and on the one side of the market, the network effect makes them to the winner. And in network industries, we have these principles now they were developed in the US, I think, 80, 90 years ago, and implemented in Europe 30, 40 years ago. And it's, first of all, it's access, it is non-discrimination, it is, in many cases, interoperability. By such principles, you're already addressing most of the problems. If you then come to a lower level, and that is the nice thing of this study, you're having different behaviors, but many of them, as Judith just said, I mean, the effect is the same. Competition law already has developed a big body of law to address the behavior. Yeah? If you're looking at much of this behavior, it's leveraging. There's leveraging jurisprudence in the US for 120 years. Yeah? In Europe, at least in Germany, leveraging exists since the 70s. Yeah? I mean, that's nothing new. It must be just applied. And I think if we do it in a mixture of ex-ante rules, where we really define what is already harmful, and then look at these classical things, and that's the attempt, I understand the EU now. And let me say one word, what you also mentioned. I think the new competition tool can only be very carefully applied. Because if it's applied to all other industries, as it is now drafted, then we are doing a lot of harm to many other industries. To me, it was only designed for these special problems. The EU now seems to take a broad approach, which where I agree is we should be careful.
Andreas, do you believe we can find a common approach in the transatlantic relations? I mean, you probably remember really the fantastic hearing in the Congress like a couple of weeks ago. It was really impressive. And it seems they have the same objective, but I'm not sure they are going to legislate the way we do.
Well, I mean, first of all, it's a bit of a problem that two of our panelists are not here. We see them from time to time on the screen. I'm sure they could also contribute something. Secondly, we are speaking about tools that we don't know the content about. So we are speaking about DSA, we are speaking about new competition tool, but no one really knows what's in there. So we are quite imprecise on this. And that is exactly the biggest challenge. We have all a feeling what at the moment in the market is unfair, and it's the others. And like that, it's very good. Mr. Kopf has mentioned it should only be on some companies, not on the others. So I think that will not work. It has to be a very clear logic behind any legislation that is done. And like that, the tool, the wording of ex-ante tool is already a little bit misleading because it can only be rules. And if these rules are broken, there will be an ex post procedure to create damages. But what in any event will change or can change the situation is that if we have not 27 different market authorities around, with 27 plus 16 data officers around, and whatever people around, but if we can create one strong authority, we would have maybe also a different negotiation tool with all companies in the world, not only with them. But obviously also we don't want to fall into a direction of planning economy or
Exactly.
big authority deciding what markets are alike. That's a very big danger. We want to have a market economy that operates independently of any intrusion of authorities, but where there are some key values maintained. And these key values, unfortunately, are not maintained at the moment. And that's our problem. So we should expect the Commission in the new competition tool to come up with ideas how intelligently create rules for all platforms that are not overburdening them, and some special rules for companies from after a certain size, on top of a certain size, and them being controlled by or in touch with by the European authority, by the European Commission, in a different manner than the European Commission at the moment is running behind them with DG Comp. They are doing a good job, but this is too slow. This is too late, and this is not enough to make sure that we keep the market innovative and to give the chance also to small companies to survive and not being bought and then being integrated or being deleted. And that's a challenge which is more difficult than we have been addressing so far, because in a legal terms, it's extremely complex to manage to fix exactly these problems.
Regarding the level playing field, thanks for the remark. I'm trying to give proportionate time to everybody. And of course, the next question go to Paul and to Olli. Paul, you even you have spoken in your report of alternatives to our current proposals that we have on the table. What is your comment on this?
Yeah, but let me frame my comment in response to the previous discussion, which was
sure that's possible.
Triggered by your question. It was triggered by your question about should we aim at fairness of process or fairness of outcome, and this led to a discussion in which Mr. Kopf proposed to use principles like interoperability, access, and so on. And here I would like to take a step back, because I'm not sure if I fully agree with that point of view. And I think a key point in these markets is that innovation goes quite fast. So market boundaries are in a constant state of flux, and business models change all the time, and there's rapid technological change. Also, in innovation in business models. So what we observe is that firms challenge each other across market boundaries and across value chains of a very different nature. And this is what you want to sort of stimulate. So I tend towards an approach based on process, because these fast changes in technology and in business models and in market boundaries will make it sort of unavoidable that you aim at the process, because if you aim at the market outcome, you are, I think, aiming at a mirage. So protecting the process of dynamic competition and entry possibilities is of the highest importance, and we should then, of course, also take a more critical look at takeovers made by big tech companies, so looking at killer acquisitions and so on, to make sure newcomers all the time have chances to challenge established companies by disrupting their value chains, so by becoming a new intermediary or by disintermediating the existing value chains. So that's, I think, the best we can hope for, because otherwise, well, these markets are quite different than the telecoms market, than the energy market, than the postal markets where we have learned so much about regulation. So this requires, I think, a different approach, aiming at the possibility that established companies can be challenged at all times. So that's what I wanted to insert as a comment here.
Clear message. I believe Olli supports your view. What's your view on this, Olli?
We've covered a very interesting topics.
Maybe come back to my previous issue. Do you feel that maybe your innovation will be affected by this move? And you see our worries. I mean, basically, we are confronted with the stable position of GAFA, and what would be the alternative for more competitive process in Europe?
I mean, look, any concern I have about a constraint on Google's innovation, prospectively, is not a reason to block new regulation, right? I mean, the Google saying that it's an innovative company, Google pointing to the things that we're doing to create new ecosystems, that is not a justification for ending this discussion, by no stretch. I think what troubles me more is the fact that at this point in the debate, that there are different, to come back to the earlier very good question for what is the vision, where are we trying to go with this? There are different versions of that, it seems to me, in the debate. There's a vision which looks at the market and says that the winners have taken all. I'm not happy with that. So the outcome that I would like to see would be more search engines. I would like to see the GAFA companies in less dominant positions. That's the outcome I'm striving for. There is another vision which looks at those companies and says they have a collection of attributes, shared attributes. We can point to certain things, the presence in citizens' day-to-day lives, the fact that they're networks, the fact that there are matching systems underlying a lot of these platforms. There are similarities. These platforms are very important. We need to pay attention to them. Moving beyond that, we accept that there are differences. The business models are very different. So as we start to look more carefully at these important platforms and how we want them to behave in the future, we need to be able to conceive of, I think it's quite reasonable to discuss places where there may be a harm that is so obvious on its face, looking across platforms, we would want to prevent that. There's an example in Rupert's and Philip's paper, I think, around a sort of naked attempt to choose profitability over relevance, right? Product innovation sacrificed on the altar of profitability. I think if you see that kind of behavior, there's an argument for per se rules that would help people move more quickly. I also think, however, that we are going to see a lot of case-by-case analysis, and this was something that President Munt mentioned in his remarks. It is very difficult. I have worked on the shopping case for some years, almost the best part of a decade now, and it is very difficult to get two people in the room who agree on what self-preferencing is. That is a fact. Is the notion of leveraging a substandard product to get ahead of your competitors troubling and something we should pay attention to? Absolutely. But we need to have the kind of mechanisms that allow us to do that in a sensible and evidence-based way. So I think that, for me, just to sort of dodge your question a little bit, I'm sorry, but I think that we do need to keep coming back to this vision, or an agreed vision for what the future looks like. It's competition on the merits, I think. It's not a particular outcome. We're not looking for distribution of traffic in particular ways. We're looking for a competitive environment where the best products win. But I do think it's important to be clear on that ultimate goal if we're going to have a sensible and practical way of achieving it.
I think we have a problem with the time. Before I ask you for really just 1 minute comment at the end, do we have maybe one question in the audience that really would like to address some specific aspect of the current proposals on the table that we have by the Commission? I don't see any voices. Maybe I can ask at the end Luis to make some final comments on our panel, and now the final remarks by Wolfgang.
Oh.
Just 1 minute. What's on your mind? I mean, we have exchanged our views, and what would be your recommendation in this process, maybe to the European Commission? And I mean, we are in the time of the presidency, and we are so basically we can abuse our position, so to say.
I found it very interesting what Bill said. I mean, I think it's less of process versus outcome. In the end. It is what President Munt said. It's about we are tackling the harm, and whether we should then really distinguish between process and outcome. That clearly, to me, makes no sense. I think we need to tackle these issues, and I agree. I mean, not everything which was used in my industry can be used for that industry, but there in these studies are more principles, yeah, and that's why I like the study and I like the discussion. So thank you for inviting me.
Andreas, your final comments on.
Well, I mean, the concept of fairness is something which is a very broad concept to my point of view, and that's what we would like to apply, but we want to avoid at the same time a bureaucratic overkill, and we want to avoid a lot of other issues, and to combine that in the right manner, that will be an extremely difficult task. And referring to the DSA and the NCT doesn't fix that problem. We have to look what will be written in, how we can define gatekeepers seriously and all this. And that's a task for the European Commission to be done.
Many thanks. Rebecca, and then we continue with Paul, and once again, Oli, and the final remarks by Luis.
I think we already talked enough about the issues that arise from the NCT and the DSA not being concrete enough at the moment. So I think one point that can't be stressed enough is whatever we do with competition law, it won't help German and European companies thrive if there isn't enough funding and the regulatory framework as a whole, so the holistic approach again, that really enables them to grow. Because what we do want to see at the end of the day is a European champion, I think. And for that, we need a holistic approach.
I was trying to avoid the term, but when you say it, then okay. Let's continue with Paul.
Yes, thank you. So the key issue, I think, that's on the table is the ex-ante regulation instrument. And I agree with the problem diagnosis and the risk of harm to consumers and to competition. But in our study, we point at a different way that could be more effective. So supplementing an ex-post competition law approach with a quick way for competition authorities to use guidelines to quickly infer abuse of dominance just by looking at market behavior without having to do a market analysis, a market definition. So I'm in general very much in favor of regulation if it helps consumers and competition. But in this case, I'm a little bit afraid that it will generate a lot of work, not only for regulators, but also for companies and politicians.
Thanks, you clear message. Oli, what would be your final remark after our discussion?
I remain optimistic, to pick up from my opening.
But it was in the beginning. Are you still optimistic?
I remain optimistic. I'm even more so. I mean, I think these are all... Look, what's important from my perspective, again, I speak as one person, but from my perspective, what's important at this moment is that the questions, Andreas has asked this several times, the practical questions about what the language says and what it will require when the rubber hits the road, if you forgive me that American expression, is crucial. And I'm optimistic because I think that there are great opportunities for Google in this process. And the great opportunities will be a clearer rulebook, a clearer set of guidance that allows us, it is not just, from my perspective, about blocking launches and holding services back. What this could be is the opportunity for the clearest set of rules to be in Europe, for the fastest launches to be in Europe. And I think that's a combination of thinking sensibly about what is typically bad, what are the things that are so bad that we want to stop them immediately. And I think it's also a function of creating processes where we can accept that we need to take a closer look and to borrow from Paul's comments, accelerate that analysis. What is it that we need to do? What is it we need to be looking at to make those decisions quickly so that companies can continue to launch products? That's my final comment.
Many thanks for your clear words at the end. And the final word has my co-moderator, Luis. I think you have the pleasure to close the session.
Yeah, I also remain optimistic that by the end of the year I might be allowed out my spare bedroom back into the world again. I think there are three challenges for the legislators, the Commission in the next couple of months. One is whatever emerges from this, it's got to be, whatever regulatory structure, it's got to be more efficient than these antitrust cases. That's the problem that is trying to be solved. Cases are too slow, they're too burdensome. It has to be more efficient than that. Point two, there has to be some kind of consensus around these harms. As Ollie said, self-preferencing can mean everything or nothing to different people. It's very easy to, for politicians to put out these words which give nice sound bites to journalists like me, but really nailing down what those harms are is going to be difficult. And thirdly, and Andreas raised this point as well, scope is a really big deal. Yeah, there's agreement that GAFA should be the target. But what about gatekeepers beyond that? People like Booking.com and Airbnb and Uber are concerned about this legislation. You go one circle further out, and you've got people like, residential real estate platforms. If I want to put my house on the market or my flat on the market, there's basically one place to go to in Belgium. That is a gatekeeper as well. How do you legislate for the GAFA guys and at the same time keep those other platforms in mind, whether you want them in or out of scope. So I think they're the three things which will be on the agenda for the next few months.
It was a clear message at the end, and I think I couldn't close better to the session. That the way you do, Luis, I really appreciate it. Especially we learned that there are other gatekeepers than GAFA. So now we're going to have a small break and then continue with the second tool of the Commission. That's the new competition tool inspired by the British model. Hört ihr mich? Super. Also ich grüße unseren Speaker. Please welcome to the discussion. Unfortunately, we have prolonged the break and we have problems with our guests, but we have to continue because we haven't discussed the second part of the new regulation in Europe, and that's the new competition tool. I think we start. We have to start.
You're the moderator.
And maybe if they listen to us outside, they're going to come. I'm glad that despite the Corona restrictions and all the hurdles, Natalie Hasdorf could make it to come today to Berlin. We didn't have so much luck last year, and to talk in person the Amazon case with Silke Hossenfelder, but I think you have followed us last year, and this year you are in person here, and it's really a great pleasure. We have in our video call Ben Schröder from Booking.com. We have Silke Hossenfelder from the Federal Cartel Office, and Marike Scholz from the European Commission. So we have three regulators with us, plus a potential gatekeeper, as we could learn from the previous comment of Louis. Ben is laughing. And I think the first question goes into the same direction as in the previous panel. Do we really have an enforcement gap that we really need a new competition tool? And we'll start with Natalie and then continue with Silke and Marike.
Yeah, thanks a lot for the nice welcome. I'm really happy to be here. First of all, it's nice to see colleagues again and travel to Berlin, and also it's a nice format. I feel like it's a late night competition talk show. You're the host and I'm the guest. So that's really nice, something new. Do we have an enforcement gap? Certainly what the NCT would enable the Commission to do is something we cannot do at the moment. So we have enforcement under 101, under 102. We have the possibility to do sector inquiries. We have merger control. That's all something that is mirrored at the national level. Then we have in some jurisdictions, not only UK, also Iceland, if we think about Europe in the broader sense, that also has a similar tool. So they have something beyond that. What we see internationally and also within Europe is a growing discussion on a rise of concentration. We have a growing discussion on expectation towards what competition enforcement can achieve for the functioning of markets. And we see that we have some structural issues that we cannot really deal with to an extent that is perceived as sufficient or satisfactory with the current instruments.
What would be the appropriate threshold for intervention? I mean, in this respect, we have some kind of paradigm shift, Paradigmenwechsel, so to say, because we basically would like to act without finding any abuse.
Exactly. That's exactly, you're putting the finger on the wound, but on the other hand, also looking at it from a different perspective, we're discussing something completely new, because we're not looking for an infringement, we're not looking to go for a fine, we're not picking out a single company, we want to look at the structure in certain market sectors. We are looking at theories of harm. We have to see, is there a real problem? For example, with tacit collusion, how can we assess if we really have a long-term problem with tacit collusion? So that is really tricky, the topic of the threshold. It has to be flexible and open, but it needs to ensure some legal security and predictability. So that is really the tricky thing here when you do this legislation. But on the other hand, it's really interesting if you try to draft this and sort of tackle it from the other side, not looking at an infringement, looking at certain characteristica that are taking place in the markets. So that's also something really interesting, and I've noticed that our economists, for example, in our agency, are really fascinated by taking this new approach. And from our national experience, but I think we'll talk about it a bit later, we also see a need for this.
Exactly. So let's continue with Silke. And I hope the connection is good. There's the same question to you, Silke. Do we really have the enforcement gap at European level that really justified a new competition tool, and what would be the appropriate threshold according to you? Do we have the first technical problems? Maybe before we... maybe the same question to Marike, and in the meantime, I believe that Silke is going to fix the problem with the microphone, I guess.
Yeah, okay. So.
Okay, perfect.
Good evening.
Good evening, Brussels.
Hello, I'm very happy to be here tonight. I mean, not there in Berlin, but just at least to the live stream. And I would have loved to come to Berlin, but these are very strange times. So this year it was not possible, but at least I can participate in this way in the discussion. So I understand you're asking me the same question you had for Silke. So what's
exactly?
The
do you see really a clear enforcement gap that must be really addressed with this complementary tool next to the ex ante?
Yes.
And what would be, according to you, the clear threshold, having in mind that the established rules that we have in different fields with regarding dominant position?
Mm-hmm. Let me maybe start with a bit of context. So, I mean, the proposal for a new competition tool is one of the measures that our commissioner announced at the beginning of the year to ensure fair and contestable markets. So the pillar, or the first pillar, the main pillar, of course, remains a vigorous enforcement of competition law and trying to go also further there. I mean, improvement is always possible through, for example, a stronger use of interim measures in appropriate cases, and potentially also more restorative remedies where there is a need for those. In addition to those, I mean, we've always said competition law is not a panacea for all market malfunctioning. So you also need additional measures to tackle certain problems in markets to keep them open and contestable and competitive. So in addition to that, a complementary measure is to introduce ex ante rules for very large gatekeeper platforms. That's what our commissioner always refers to as clear do's and don'ts. To tackle certain unfair practices or proven harmful conduct. And the third measure, or the third pillar in this approach, is the new competition tool to complement these two pillars to address structural competition problems that cannot be covered by the current rules or cannot be addressed in the most effective manner. So it's not really an enforcement gap as such, it's really complementing a complementing element, a reinforcing element in a toolbox of three different measures that would work towards the aim of ensuring fair and contestable markets. It was already mentioned, I mean, there are certain elements or certain structural competition concerns that we cannot tackle at the moment. Tacit collusion was mentioned, anti-competitive monopolization strategies as well. So there are different scenarios that the current rules cannot cover. In particular, if it's about conduct by non-dominant players with market power that maybe are on the verge of getting there, but they don't fulfill yet the concept of dominance under competition law. And then on the side of things that you cannot tackle as effectively, an example that we are always giving is parallel repeated leveraging into adjacent markets. So for these cases, of course, you can run a case under Article 102, abuse of dominance, and we've done a couple of cases. The problem is that if you have this conduct occurring in a repeated manner, you have to run a separate case for each of those instances. And that, of course, takes time. So if you were to address this problem from a more market structure-based approach in a holistic market investigation that covers the core market from which the leveraging is taking place and the adjacent markets, you can really take, as I said, a more holistic view of the problem. You can come to a principle-based remedy, and you can also look at the source of the leveraging in the core market. And these things are not possible in the current setting if you have separate cases dealing with that, apart from the time factor, of course. So that is clearly where the new competition tool could come in and could help to tackle certain problems. And now coming to your question about the legal test, I mean, it is about market structural features that are not caused by the firms, but they can be reinforced, of course, by conduct. But all of this needs to have an outcome or an effect on competition. So there needs to be an inefficient market outcome in that sense. So there's no automatism of saying there's a structural feature that leads to certain developments and automatically you would have to come in and remedy that situation. It's really about making the link of how does that affect competition in a particular market. In the UK, the test they use, the concept they use is adverse effect on competition. I think it will have to be something along those lines, right? Where really you have to prove what is the effect on competition in the market you're investigating. It needs to be, as was also said by Natalie, a concept that's sufficiently encompassing. I mean, in the same way as abuse of dominance, right? It's a concept that has to be filled with life. But you need to be sure that you can cover different scenarios under that all amount to a similar problem. But of course, it needs to be a predictable test. So there needs to be a way to make clear that market players understand what you're looking out for and what possible theories of harm could fall under that. So the CMA has done that, for example, with guidelines. In Article 102, you have a list of practices, which of course are not exhaustive, but examples of what an abuse of dominance could be. So there are really different techniques of how you can do that. But what is clear is you have to have a clear test and a predictable test. Make sure that that's a workable instrument.
Many thanks, Marike, for this statement. Maybe we should try again with Silke. I hope in the meantime the technical problems are fixed. Silke, do you hear us?
Well, I hear you. Can you hear me?
Perfect.
Oh, that's great. Because, wonderful. Okay.
Perfect. I thought maybe you're still in the federal cartel office, and maybe because of that, because of some strict restrictions, but that's not because of that.
I'm at home, as you can see. My office in the federal cartel office does look a bit different.
So there is, I can promise you, there is no danger of any data leak in the meantime of current ongoing antitrust procedures. So we can freely speak tonight.
I just want to mention maybe your technicians can do something about this. I'm hearing everything double, but with about 1 minute time difference. So I'm very strange.
Maybe
I'm trying to concentrate. Huh?
Yeah, all micros must be switched off for those that doesn't speak currently, please. That's the only remedy I can recommend at the moment.
Okay.
So
maybe to the question whether there is an enforcement gap. I think that the discussions that we are having had in the last years and picking up in the last months, I guess, about digital economy and the question of how we solve the issues there does show that there is a sort of gap. I think from our perspective in Germany, we would say that the discussions that we have been having here for the 10th amendment of the competition law also show that there are things that you might do in order to be able to tackle these issues more effectively. And from our point of view, I think I can say we are very glad that the Commission is proposing these two approaches, and really is discussing now about how to be more effective in these areas. So, and then, of course, in Germany, we have a long tradition of also looking at markets which are not yet dominant and where nevertheless there might be problems with competition because our abuse control allows for interventions even below the threshold of dominance. And what we understand from the ideas around the new competition tool is that this might also be an option with the new tool if there is a structural competition problem which would need to be defined, of course. So I think it's good to talk about this. I personally would not think that for something like the new competition tool, it's easy or makes very much sense to define a threshold, because I think competition problems in markets might arise in different sizes of markets. So I think this concept of threshold is a bit difficult to put in this model. And I think the next task now, and I very much agree with what Natalie and Marike have said, is that we have to, of course, define structural problems, competition problems more specifically now in order to make it a legal tool, because until now I think it's more an idea, and we need to put more flesh on it, and that's why we are discussing these issues now in a broader public.
Many thanks for your initial statements. From the perspective of a potential gatekeeper, Ben, are you listening to us? Do you see enough legal certainty in the new competition tool? And what would be your comment on this regarding the threshold and the potential enforcement gap that we currently have in Europe?
Well, thanks for having me. I hope you can hear me well.
Perfect.
Well, I think we need to separate things here, right? We're on the one hand, we have the new competition tool. On the other hand, we have the gatekeeper regulation. And so far on this panel, we've been focusing on the new competition tool. And we've come out in strong support of the new competition tool because, as all my co-panelists have laid out, there are some features of markets that currently cannot be tackled by competition law effectively. You can have markets where there's no abuse or not even a dominant company. You still can have a market that's not really tending towards effective competition. And if you look at stuff like consumer inertia, consumer myopia, high switching cost, barriers to entry, I mean, all the stuff that you can find in your average competition economics textbook can tell you the conditions that you really need to be looking for. So we think it's good that the competition is tackling these issues, and we would like to see a very broadly applicable new competition tool. So I would actually put a very low initial threshold to start a market investigation, because I think a market investigation is actually a good way to generate knowledge about markets, in particular about highly dynamic and fast-changing markets, before you take decisions that have potentially very far-reaching consequences. And I think you can only make your decisions better if you have a lot of information. And I also like to believe that with the maybe less adversarial procedure of the new competition tool during the market investigation phase, companies and authorities could come to a better joint understanding of how markets are developing and what the big trends are and what this means for competition. And again, I think this is in everyone's interest. I'm a little bit more skeptical when it comes to tipping markets. We've not really touched upon this yet. Because, I think I'm the sole economist on this panel. And of course, as an economist, I have to say, you can have efficient tipping, even to monopoly. So I think we need to make sure that whenever we look at tipping, it needs to be clearly linked to anti-competitive conduct. And then I definitely see a use for the new competition tool as well. Final remark in this initial round, we would really like to see a broadly applicable new competition tool. So not just applicable to the digital economy, but across all sectors. And that is one of the options the Commission has put on the table. I'm a little bit worried from the latest leaks that we've probably all seen that maybe the Commissioner is more tending towards a less courageous approach. A little bit short-sighted, and it would definitely take away from the overall rationale. So I hope we get to a new competition tool that's really applicable to all markets in a very broad.
Many thanks, Ben. I have a concrete question. I would really kindly ask you for a short answer. Should the new tool be designed to address only harm that is already happening due to structural market failures and can therefore be evidence? Or should the new tool address harm that is hypothesized to happen in the future due to structural problems on the market? Maybe, Natalie, we can start with you.
Thank you. First of all, if you mean it in a way that it should not be limited to dominant, to a situation where you have a dominant player in the market, then certainly I think it should be broader. Because we do see that especially these structural competition problems come up also in situations where you wouldn't find a dominant player in the sense of the current definitions. Also, you have to keep in mind that there might be irreversible damage if you have to wait for a scenario to materialize, but there have to be clear indicators for the theory of harm, so it can't just be a fantasy. It has to be something that you can grasp almost. So I think there you need to strike the balance with predictability of what authorities do. Although I just have 1 minute, right? But I don't think that competition authorities would have a tendency to go too deep into regulatory, in a regulatory manner, because competition authorities would tend to, I think, restrain themselves also to very, to scenarios where they really think that the damage could materialize.
Okay. What would be the comment by Marike and Silke and also Ben on this issue regarding the potential harm or actual harm that is happening? Marike?
Okay, happy to... Silke first?
Yeah, you take it, please, Marike.
Okay. No, I'm happy to go. I mean, my reply, of course, is clear because our proposal covers both structural risks for competition and also the structural lack of competition, which is the malfunctioning of a market. So the difference being in one scenario that the harm is about to hit the market, but hasn't caused harm yet, but is very likely to arise. And the other one, of course, where the harm has already occurred. And in the first scenario, so in the risk scenario, I mean, it is tricky to make sure that you do not intervene too early. It's important to really find the right balance between the benefits of keeping a market open and a risk that there could be a too early intervention that could harm innovation and investment incentives. Of course, I think that's something you have to balance in some way or the other, and of course you have to look at indicators. It always depends on what problem you're solving. I mean, you can have a situation where you already have a benchmark in other national markets where dominance has been reached already, and other national markets where the same player is operating and the same structural characteristics are applicable in the market, where of course you would have to sit back and wait if you were to go for an approach under the existing competition rules. That, of course, is an easier scenario, I guess, than if you have a global market or an EUA-wide market where you have to find a benchmark to understand when there is really a risk for competition and a need to intervene early.
Many thanks. Silke, please.
Okay, yes. Can you hear me?
Yeah, perfect.
My first question. Okay, good. So my understanding from this tool is very much that you might have to think a bit more from the remedy side. I mean, from what you would be imposing on market participants in order to alleviate the problems or the tensions that might be there. So we're not thinking about telling people that they've done something wrong and we want to maybe impose fines, etc. All of this is not part of this tool. It's about thinking and coming up with ideas on how this market will function better in the future. So it's not, I mean, I agree with Marike that we should not intervene too early, but I think it's not so much I mean, all that we would want to be doing, I think, is to make sure that innovation would be able to continue, but not only by one, but also others possibly. So making the market work better. And so I think it's not so much the question here whether we intervene at a point in time when harm or abuse has already taken place, because that's the whole story about trying to make these markets work better, actually.
Many thanks. Ben, who do you expect to be the first target of the tool? The GAFA markets have already tipped and they won't tip again.
Well, that's a good question. I'm not sure I'm the right person to answer that question. But maybe I can say, because maybe that's what you're implying with the question. Are we afraid that we could be potentially a target? And then I can firmly say we're definitely not afraid, because we think this is a valuable tool, and there can be a lot can be learned from having market investigations. I think it doesn't come as a surprise that when I say, maybe in the past we haven't always been 100% happy with the way some investigations into our business have been run, and they haven't been. And from, at least from our point of view, the authorities have not fully understand the market dynamics and the important features of competition that's taking place in our market. And my hope is really that with such a tool, we could get a much better understanding, because there are no fines in the room. It's at least in the beginning, as I said, much less adversarial. We're definitely not concerned about it at all, and that's why we put our support behind this tool.
Many thanks. I've already mentioned that I'm not alone in this moderation, and I hope Louis haven't left me. Louis, are you listening to me? Perfect.
Always.
Always. That's good. You have many thoughts on the new competition tool. What would be the most worrying thing that you would like to address?
Well, I think it's clear that there's certain market phenomena that fall between the gaps, and that's what Marika's been talking about: tipping markets, entrenched competition problems, which with the current tools are difficult to land a glove on. So I think it's fair that there's some innovative thinking about how to do that. I think the difficulty is, and we saw this from the last panel, is how does this NCT fit alongside the gatekeeper legislation? How do they fit together, both conceptually but also organizationally? What's the hierarchy between them? And I'd actually take that one step further. I go NCT, the gatekeeper legislation, then you've got other sector inquiries, and then you've got Article 102 or 101 investigations. There would be, for certain kinds of companies and conduct, it's clear that they will fall into certain pots. But for other conduct, it could fall into one pot, in May, and in October, it could fall into another pot because a market is tipped or is tipping or whatever. And I think, so my question is, how do you give clarity to companies about which of these tools is in play? Do you leave it discretion to the Commission to decide which is the best tool at any one time, which I think is probably fair? But then a company might not know if it's going to be hit now with a sector inquiry, tomorrow with a NCT, tomorrow with a gatekeeper, or then with a 102 probe. I just wonder how. I don't expect Marika to know the answer to this because it's obviously under consultation, but maybe Ben's got a view on whether there's uncertainty there.
So maybe we start this round with Marika and then Natalie and Silke.
Okay, happy to go first. No, indeed. I mean, the consultations are still ongoing, so it's difficult to say what's going to be the final outcome. But the objective is what I said initially, to come out with a proposal that is complementary between the two pillars, so between the DSA initiative and the new competition tool and the existing competition law. And if you look at 101, 102 and the NCT proposal, as I said also initially, the main focus is on areas that we cannot cover under the existing rules. And there may be that, small overlap of cases where it's about doing things more effectively because you can take this holistic market-based approach. But I don't think that there's going to be there would be a lot of situations where you would be deciding between the two because they're having a totally different approach and focus. I mean, the NCT is really based on a market structure-based approach, looking at if it's for the risk scenarios, ensuring that markets remain open and ensuring contestability. And for the other, for the scenarios of where you have this overlap, of course, it's really taking a different approach from what you can do under competition law. And the NCT does not have a conduct focus. So in this sense, I don't see a problem with having these two working in a complementary way. I don't think it would be helpful for the effectiveness of the tool to have a kind of decision moment where we would have to explain why we don't use 101 or 102, because that's what some people have suggested. I mean, if you request that, it essentially means that we would have potentially to litigate before even being able to start a market investigation, whether we are allowed to investigate, because there are indications of a structural competition concern. That would be very difficult, and I don't think that this tool would then have any practical importance or relevance in our toolbox. So I think that there needs to be, at least to that extent, discretion. But of course, if there is a scenario where the two could overlap, I think we have to explain why we believe that a market structure-based approach is more appropriate. And then we look at that particular market from this NCT perspective, do the investigation and prove what has to be proven to the requisite legal standard under the tool. So I don't see an issue there. Then when it comes to the DSA, of course, I think the benefit of legislation or regulatory solutions is that they can, bring clarity, immediate clarity, and a quick solution to the market, because you can really look for clear-cut do's and don'ts, as our commissioner always says, so clear-cut prohibitions or obligations. Obligations may have to be tailored, of course, to a particular company, because we've heard in the previous panel that business models are different. So, you really have to look at how a particular obligation would then have to be implemented. But that's more a question of implementation and not a discussion about what's the theory of harm or, what kind of problematic behavior am I seeing. So from a competition perspective, based on the experience we have with the enforcement, the complementarity lies in using, the strengths of a regulatory solution that's clear-cut, quick, and gives immediate clarity, and then everything that requires a case-by-case assessment from a competition perspective, because you're not sure about the effect that a certain conduct or a certain market structural issue has on the market, either under the competition rules, if it's a conduct focus, if it's an abuse potentially, or from a market structure-based approach under the NCT.
Many thanks for your clarification. Natalie, how do you see the interplay of too many tools and the issue of legal certainty in this respect?
I think it depends a lot on how the tool actually looks like at the end, because there's less overlap. If it's a broad horizontal kind of instrument, then you might see less overlap than if it's a very narrow instrument, which is also tailored towards maybe specific companies. So it depends a bit on that. And then I think you have to differentiate, on the one hand, the question, how much discretion does an authority have to choose a tool, and under which conditions would it use which one, and should it give guidance? And then on the other hand, you have to look at procedural safeguards, like if the information that is given under this instrument, which is not an adversarial procedure like in 102, what can happen with this information? So there are a lot of procedural issues here, and where safeguards will be put into place, I guess. Although you have to keep in mind that it's not a procedure that is aimed at finding an infringement or a fine, so we're not in this quasi-criminal regime, so it's something else. But I can share that within our agency we had a very open discussion about the tool and the different options and what we think about it. And we try to think about scenarios and cases and sectors that we've looked into, and whether what would we have done, would it have been a useful tool or not. And it seemed to us pretty clear-cut. Only in very specific scenarios you would see, okay, we have really this structural problem in the market. We cannot solve it with the tools we have, although there might be a need for it. So in our discussions, we wouldn't have seen much of an overlap. It seemed pretty clear to to our teams in what kind of scenarios you would go for it when you look at it from a more practical and not a theoretical side. But you think about what cases have we done, what markets have we looked into?
Yeah.
Yeah.
Silke, are you sharing the view of Natalie as a national regulator, so to say?
Yeah, I mean, I think I share Natalie's view, but also Marike's view, and I think actually, I mean, in our discussions on this tool, we've always put forward that from our point of view, it should be really, it's necessary to have a clear complementarity between instruments, because and I think that was part of the discussion in the earlier part of the conference that Philip, I think, said. So we don't want conflicting competencies. We don't have any time for that, discussing about who's more competent, people who are imposing or enforcing the DSA or the competition authorities. I think we should really concentrate on enforcement measures that have a real impact and make these work. So I think it's very necessary to come to very good complementary tools so that we don't have that in the end. But if we have that, such a regime in the end, I think also that these tools can very much profit from each other, because in my view, for example, many of the digital market issues that we've been looking at in the last years might, in cases, but also outside of cases, all the discussions that we are having could be good issues for the new competition tool, for having a market investigation, for looking at structural problems in these markets, where you would then come up maybe not with the necessity to really have a prohibition decision on a specific conduct, where we might here and there not be sure yet. I think somebody said in the course of the debate, what is self-preferencing? There is so much debate on what it is in effect. That might help to come to solutions to make markets work better. And that might be easier also for the companies that we are talking about here to come in a debate with us if they do not have to fear fines, even though the fines that we are imposing on these companies currently might not be so much of a problem for them. But an adversarial procedure is always something completely different from a non-adversarial procedure. It makes it easier to come to get into a debate with the company on better solutions than if you have an adversarial situation.
Many thanks. In order to have more time, to have enough time for the last session, we'll finish this session like in 10 minutes. Maybe there are some questions in the audience. Please keep it shortly.
In 2019, Margarete Vestager had a competition law conference, and one of the great keynotes there was from Jean Tirole. He was a Nobel Prize winner in economics, and he pointed out that there is a part of the regulatory measures that lies outside of competition law. This is also something that we have discussed in the last 3 panels, but we couldn't put the finger on it, what that part actually is, right? We've looked at it from a scientific standpoint, and we think that a large part of the market output can be explained with regular market failure diagnosis tools. Information asymmetries up to adverse selection, external effects, public goods. So the whole range of market failure, we thought that there's, when we check the digital markets, we find ample evidence. Now, what I'm a little startled about is that if the diagnosis is market failure, then there is an economic rule book that we seem to have tossed out of the window how we deal with information asymmetries and adverse selection. There's an economic rule book, how do we deal with external effects, and how do we deal with public goods. So the question, in order to come around towards the question towards the people in the panel is, do you think that we have this market failure, and why are not we applying the textbook rules? Because we did, and we have come up with solutions to some of these issues, like the liability issues, for instance, that we think are very capable. So why are we not applying the standard market failure rulebook to this range of problems on top of the competition law issues? Thank you.
Questions goes to your preferences.
Ms. Marike Schake and well, everybody else who thinks they want to answer.
Marike, the pleasure is yours.
Thank you. Okay. Well, if I understood correctly, that was a pledge for actually more regulation, because if I understood correctly, it is about things that cannot be tackled under the competition rules, and where you have a systemic issue, so a systemic market failure, and why we aren't regulating more. Well, I mean, that would then be part of what's being looked at in the moment in the DSA work stream, where we're trying to see which are the systemic issues that would require such a reply. So that's all I can say to that. But maybe the question was broader and was actually referring to other areas of law. But yeah, maybe others have some comments on that as well.
Okay, we have one more question. We have a guest from London, and really appreciate it that you're with us. Please, Chief.
I say that's a great way of getting everyone to stay away from me from now on.
No way.
I was going to say this. Look, I have a media background, and as a journalist, you sort of realize there's this concept of chilling of free speech, right? So it's an action that takes place off in one corner, and then everyone else gets affected by it. It's very hard to detail exactly how that happens. So it's a nebulous concept. But there's a chilling of innovation as well when you have these giant monopolies, because often when you go to these companies who are sort of downstream in a vertical, their strategy, they might not shout it from the rooftops, but you'll figure out their strategy is just to get bought out, right? Pose enough of a threat to the players at the top, to the player at the top, and hopefully they'll get bought out. That obviously chills innovation because they don't want to do anything else except get bought out and just pose that enough of a threat. How do you measure something like that, the chilling of innovation? Because that's quite difficult, it's quite abstract.
How do you measure this? We are asking for effect-based approach when it comes to the new competition tool. Who would like to comment on this? I think the message has been understood quite well, but I
maybe can I?
Maybe Silke, okay, please.
I mean, you're asking about killer acquisitions, and the question of, from my understanding of your question, and whether we know how to measure whether an acquisition is a killer acquisition or just a normal one. Difficult. I think nobody of us has until now been able to put its finger on one of these. And from our understanding also, the large tech companies that go into buying lots of small companies that come up with new software ideas, or whether don't know yet whether this is going to be a success either. So I think it's difficult to say whether this is really a competition problem or not. And I think you can see that until now, as far as I know, there is no competition regime where we have a provision for such an intervention possibility of competition authorities. Having said that, maybe something like the new competition tool would at least make it possible to look at these things again and intervene at a later point in time. I think, Pencho, you had said, what is the sense of intervening in markets that have already tipped? I think there is a lot to do there and to try to at least alleviate the situation. I mean, we're not going to put our hands in our down because the markets have already tipped. I mean, we will be asked also to come up with solutions for these situations. And of course, if we have a tool like this new competition tool, all the more.
Okay, Natalie would like to add something?
Yeah, just like to add to that one thing is, of course, how do you even get to review such a transaction? And for that, at least in Germany and Austria, we have this transaction value test. But even with this instrument, we are not sure if we really get to see those kind of critical killer acquisitions that might be out there. And then another thing is what we try to do is to really, in our assessment, to get a good look at internal documents and really try to get an idea what is going to happen. But it's extremely difficult to really look into this crystal ball and see, as Silke said, even some of the companies buying those don't really know exactly how innovative and successful those startups might be or not, and their ideas. So, but I think authorities are trying to get there, and we certainly try to do that in our investigations and assessments in the merger process.
One more short question, Thorsten, please.
To make it very short, just to give you a concrete example, just during Corona crisis, one of the governors who was offering infrastructure is giving loans to lots of startups for a very good price, so that they can still use their infrastructure, with one clause in that: if they will cancel the contract with this company, they have to pay back that loan at once. So that's the power of liquidity, which is heavily misused, not to buy one startup, to buy a bunch of them and just to see which one will be the killer app, and then you are too late.
Good example. Many thanks. So I think we have reached the limit when it comes to the time. I really appreciate your view on the subject matter. Still, I would like to hear your final remarks or recommendation, since we are approaching the process of legislation till end of the year, and maybe we start with Ben. Then Silke, Natalie, Marike, and of course the final comments by Luis.
Sure, happy to offer some final remarks. So, I mean, we are anxious and excited for the Commission proposals to come out by the end of the year. Maybe there's also some worry in there when it comes to the gatekeeper regulation. Because I think here it's going to be crucial to get the criteria right, to make it not too broad, and then also we obviously have to see how the interplay is going to be with competition law in that respect. But I mean, in general, I think it's worth highlighting that when I look through all the panelists of today's panels, there's a great degree of I think we all share the sense that there are some problems out there that need to be tackled, and it's good that something is happening. And then, I mean, as it is always, the devil is in the details, and I'm sure we're going to have some exciting discussions for at the end of the year and then throughout the next year.
Many thanks. Silke, please.
Yes, thank you. Well, as I said, we are happy that this discussion is now taking place at European level on both issues. We are very much in favor of clear delineations of instruments and competences between different sectors of law, especially, I mean, within the ECN, we have possibilities of dealing with parallel competences, but I think this is a different issue with regard to the different areas of law. And we hope that all of this is going to help us to implement better competition mechanisms in these markets.
Many thanks. And maybe to speed up the procedures in general.
Well, part of it.
Part of it. Part of it. Natalie, please.
I'm very optimistic because when I think about what was on the table at the beginning of the process, and if I look at the content of our very constructive, I think, discussions with the Commission, which we're very thankful for, I think it's a very good process, and they're looking for all the input they can get, also from the national authorities, and we're getting somewhere here. So I'm very optimistic about it. I think it's a great opportunity to make competition law work for scenarios where we didn't have a tool up to now. And I think it's a possibility to meet also some expectations to what we want from competition law enforcement in the future.
Many thanks. Maybe, Marike, you can tell us something regarding the time frame. What do you expect this to happen? And your final thoughts.
So we are at the moment finalizing the evidence gathering phase, and we hope to be done with that soon so that we can publish the results of the different work streams and also the expert advice that we have commissioned so that everyone can see what we have been working on during the last month. And the possible legislative proposal is still scheduled for the end of the year. So there's a lot of work ahead, and we promise to work very hard to make that happen if that were to be the decision. And I can just, repeat the commitment to come out with a complementary proposal that really explains to the market how these different, legs or pillars will work together to give a coherent and consistent reply to the challenges we're facing at the moment.
And I truly believe that our study helps you a bit, at least in this direction.
Absolutely. Thank you very much for that.
Luis, it's again the pleasure to summarize some thoughts regarding this tool.
Look, I think there's been clearly a gap identified, and the Commission should be applauded for trying to fill that with a piece of legislation. This is not easily done. It's much more difficult to construct such things than it is to destroy them, as the conference circuit usually attests on these things. And the sign that people realize how powerful it could be is in the arguments you find over the scope of it. A lot of people don't want this tool to apply to them. I think the nuts and the bolts are going to be in the threshold for starting one of these, the threshold for intervening, the kinds of remedies. I think there'll be a lot of litigation over that, and Marike can look forward to that in the years to come. And finally, I think one of the big questions, the criticisms, the complaints that you hear is, if you look at how the UK does this, these are non-adversarial procedures, as Silke said. Non-adversarial means more transparency, means publishing the submissions, means being out there and being open about what's going on. And that hasn't always been one of the great fortes of the European Commission, to put it euphemistically. And also, defence rights is a classic. You look at these cases in the UK, they get litigated every single step of the way. There are litigations about the interim reports, about the information gathering, about the remedies. Will the European system with its court review be set up to manage that? I think that's another big question.
Perfect. I had the pleasure to have the best co-moderator from Brussels. Really, I'm always fascinating by your thoughts and your comments in Emilex and on Twitter. And it was really a pleasure to discuss with you. Of course, my special thank to the speakers and for coming also from Vienna, especially to Natalie. I have the understanding, of course, that Silke and Marike couldn't join us this time, but we really appreciate your view on the subject, and we're really grateful for that. Many thanks. Have a beautiful evening and continue. Please follow us in the coming session. Now we have small break of 10 minutes, and then we continue with the most difficult issue, privacy. Okay, it works. So probably this is the latest ever discussion on the subject privacy and competition. But I believe that having in mind the current developments on the competition markets and generally regarding the possible new regulatory steps that we expect at European level, this discussion deserves attention, a lot attention, and I think the subject is really, really appropriate and could be also touched upon also in the previous session as well. Many wonder, do really privacy is a competition problem? And now we have a really pioneering case with Facebook in Germany. And we have all written really wonderful academic papers in this respect. I really enjoyed your latest academic inputs on the subject matter. And I really appreciate that Simonetta could join the discussion came from Switzerland extra for this panel, and then Ioannis from Greece. And it's really a great honor for us. And this is probably the only proportionate panel in this evening, since we have two ladies, and I'm really happy for that. So let's start. I must say in the very beginning that I got inspiration for this topic from your draft paper, Aline, and it was actually your suggestion. Where originally I said, when privacy affects competition, and then she called me. She said, "Pencho, maybe you should rephrase it to be more suitable, and maybe you should say when privacy meets competition." So, because of you, I have rephrased it. What's your thought on this? How does privacy affect competition? Privacy meets competition.
Well, I think there are various interaction points, and maybe to come back to your first question, is privacy a competition problem? And I think the answer to that is, well, it depends, and it depends exactly on one question, and that is on whether competition concerns lead to or aggravate privacy concerns. So we shouldn't try to make privacy generally a competition concern. I think we shouldn't generally make GDPR enforcement a matter for competition authorities, but I think there are specific instances where privacy becomes a matter for competition. And that's, for example, in the merger context. If you have companies competing on privacy, even if it's not the main parameter of competition, then a merger can lead to, well, a worse privacy outcome. Or also if consumers face a dominant firm and have to make choices about their privacy, there may also be a privacy, there can also be a competition problem if consumers don't really have the same kind of choice to give their informed consent about how their data is used. So in those cases, we have an interaction. That doesn't mean that always it's just a matter for the competition authority to look after it, but they should certainly be aware of those matters and try to, well, grapple at least with the kind of competition part of it that's contributing to the privacy concerns.
Many thanks. The same question to you, Simonetta, maybe with one supplement. Is the GDPR really in favor of having more competition in Europe?
Thank you. Question? Ladies first, that's it. Oh, sorry.
It's already on.
It's already on. Okay, so again, Pete,
and it's only for you.
Thank you for the very interesting question. Well, I don't think it's really possible to say generally whether GDPR is in favor of competition or not, because, well, we have to go back to understand what the GDPR is. GDPR, as you have also written in your paper, is a sort of minimum level of protection of a fundamental right. Okay, so it was not the purpose of the GDPR to create markets for privacy, markets for data. It was not the issue. And then, of course, that's a problem with the GDPR, I think also because they could have done more to create markets, well-functioning markets for privacy. It was something that was not considered at all. It was this part of the economic approach was totally disregarded by the ones who have been working on the GDPR, perhaps also for good reasons, because they didn't want the economists to jump in and perhaps scramble eggs. So they really wanted to keep it in the area of the privacy. So I don't think it's really the purpose of the GDPR. I think the GDPR actually is technology neutral, but it's not value neutral. And that's extremely important. But when we think of slavery, things or the issues we have, many things would not happen because of the GDPR, because there are values there. And there are not only values, but there is also a sort of direction for us all in the way that we want that economy to develop. And also there is another thing very important, there are incentives for privacy-enhancing technologies. So there is quite a lot. So tangentially, I would say yes, they affect markets. It's not the purpose of the GDPR to decide how much competition there should be.
Okay, many thanks. Ioannis, you're advocating for more taking into consideration of privacy as a concept within the competition enforcement. Why is that?
I mean, there are different reasons why we should care about privacy from the point of view of competition law. As it was mentioned before, privacy can be a competition law problem in the sense that the lack of competition in a particular market might lead actually to reduced privacy. But this is not the only reason why we might have a privacy problem. There might be other sources where actually we have a market failure that could lead actually to a loss of privacy. For instance, you can actually have a lock-in effect of certain consumers to a particular, let's say, platform. That could be possibly a competition law problem in some jurisdictions, those in particular that have rules on economic dependency or relative market power, like in Germany, not in other jurisdictions where actually market power is much more narrowly defined. You may actually have asymmetry of information problems that could actually also lead to loss of privacy. And asymmetry of information might actually be possibly a consumer law problem, or it could possibly also in some competition law regimes be also a competition law problem in case the asymmetry of information is a source of market power. So I think it's from my perspective, because actually we can think of the lack of privacy as a possible market failure, and therefore not break a little bit with the approach that the data protection law has been inspired from, which is more a fundamental rights perspective, Article 7 and 8 of the Charter of Fundamental Rights. If we take a different approach, a more, let's say, market failure perspective, there we can actually see some room for privacy concerns in competition law.
Many thanks. I think also in the similar direction, maybe would go Wolfgang. Why do you consider actually that the GDPR is sufficient to deal in competition cases? Is it true, my understanding of
the GDPR is sufficient?
Sufficient when dealing in competition cases?
No, I think if you have a privacy problem, so the question is whether competition law can really take into account privacy problems. So my point is that this is a discussion about the Facebook case, and the most counterposition.
I thought maybe we come to the Facebook case in the second room, but you can touch upon even now.
No, so the point is about this separation approach. So it's the discussion whether competition law should only focus on competition problems, and privacy law data protection law should focus on privacy problems, and therefore if there's a privacy problem, then this is a matter of privacy laws. This is a very important position. Also the European Commission exactly had this for a long time. Now the question is that these two different kind of laws, they are interacting with each other, and behind these laws are market failures. This was already mentioned, and we have information asymmetries on one hand, and we have competition problems, and these market failures also are interacting with each other. So we have often effects, especially in the digital platform markets, where we have effects, negative effects on both privacy and on competition, which are jointly caused by both market players. And I think this is the real important problem, that in the digital markets we have both information and behavioral problems, and therefore the consumers cannot really deal with privacy policies, are overwhelmed by this. And at the same time we have the competition problems. And the problem is now, what is now the division of labor between both different kind of policies? And the point is that you cannot really separate this anymore if these are intertwined in that sense. And this means, from my perspective, that competition law, I think, has to deal with privacy problems if they are caused by competition problems. I think this is also what you meant. And then they have to deal with this, and this is on one hand because data protection law cannot do this. It's a privacy problem, but data protection law cannot deal with this because they have not the remedies and they have not the expertise for really making market definition or for really dealing with competition problems. And they also really only, as you said, it's about a minimum standard of privacy, but we would expect more than that. Yeah, and therefore data protection law cannot do this, and so competition law has to step in these cases, and mergers is one, and the Facebook case is another. But we can also think about cartels. I think cartels is an interesting thing. If firms in a certain industry really make a horizontal agreement about privacy policies, for example, which might comply with GDPR, but it's still anti-competitive, then this is a competition law issue, and only competition law can solve this.
Many thanks. Sebastian, you're a competition lawyer. From your point of view, not including mergers, is privacy really a competition problem? From a practitioner's point of view.
From a practitioner. First, thanks for this question, and I highly agree with Wolfgang Kerber's meaning of there's a separation between competition law at once and privacy law at the second. But it's not separation, it's overlapping too. And overlapping in, and this is the practical problem, overlapping in a meaning like there could be a privacy enforcement and an antitrust or competition enforcement both ways. And both ways because of this. When you take a look at the privacy law nexus, I'm using this nexus term because of the Federal Cartel Office's saying this. The privacy law is giving a nexus for this whole fundamental right concerning privacy. But these are not fundamental rights concerning privacy. It's the same fundamental right concerning freedom of choice or freedom to get informed. And these fundamental rights are involved into competition law. And that's why there are possibly two ways of enforcement. And the first way, it is a little bit mixed up with this Facebook case, is taking privacy law directly and trying to do antitrust enforcement via data protection. This was the Facebook case. It ended positively for the Bundeskartellamt in that way that the result was confirmed by the BGH, by the Federal Court. But I disagree. I'm not sure Andreas Mund is still away. I disagree in that way that the court confirmed the theory of harm. This is not true because the court disagreed about the theory, about the basic theory, and this was not like taking privacy law directly. We are just enforcing competition law. And competition law could, and this is the way back to my first saying, competition could be fundamental rights enforcement.
Many thanks. We officially opened the Facebook case. We couldn't avoid it. That's absolutely
Sorry.
Okay. Please.
I'm not about the Facebook case, but about what was mentioned before, because I think it's quite important to understand the complementarity of competition law and privacy protection. If you actually have an opt-in, a default opt-in case, as actually, for instance, we have in the US, where, with the exception of some states, you don't really have a protection of privacy. Then in this particular case, we have a possibility to move to a default opt-out, as actually we have in Europe with the GDPR. So that will enable a person not to actually have their data harvested and collected without actually their consent, right? And this is really, the position we have here. But that doesn't necessarily solve the problem. And what could be the problem? The problem is that they are, harvesting this data without necessarily paying the price for it, right? Or the just price for it. Okay, let's use this term. And that is actually why, the reason why this is happening is this asymmetry of bargaining power that you have between the platform, which actually collects this data, and the individuals, right? So from this asymmetry of power, actually, this is something that data protection law cannot solve by itself, because this happens also in the context of the GDPR, regime like the EU, and therefore you need in this context maybe something else, another type of remedy. You can call it actually competition, could be competition law, it could be actually a different type of tool that will possibly, solve this particular problem and enable the market to be established. In which case, some people that could be more privacy oriented will prefer to pay for the use, for instance, of Facebook or Google, and not for their data to be harvested, and other people actually, to be paid for it, right? So in a certain way, I think this is the lack of this market is what actually is the source of the problem, and competition law might actually help there.
I really appreciate your way of reasoning in your latest paper and explaining that in the context of what does it mean price in the context of prices, like exploitative abuse, and in the context of data protection. But let's move to the difficult issue of theory of harm. As we know, in the higher regional courts rejected that notion, and we have basically confirming the abuse of dominant position by the federal Supreme Court, but with a slight of different reasoning, so to say. What's your view on this? I believe you have read to the last letter the reasoning of both courts. Where do you see the real harm on competition in this case?
Well, yes, I read the decision. So I read the decision, and of course, I thought it was surprising and quite exciting. Before going to the theory of harm, I would say that perhaps 3 reasons why I really liked this decision. Well, first of all, that it's really pointing us in the right direction. Reframing the debate, it's not just about...
You're talking about the latest decision by the federal...
you say the Oberlandesgericht. We are still discussing the intermediate? Yeah, okay, so before the...
No, I'm talking about the boat, but simply
so
we have different
I'm just
reasoning.
thinking of the federal, the last one, okay? The one confirming the Oberlandesgericht. So, I thought, well, of course, it was quite tricky. It was surprising. And so that's why I'm saying it's putting us in the right direction, because there was the discussions, we discussed it also with Wolfgang Kaber, it was the discussion about an abuse of dominance based on infringement of the GDPR. That was a good idea based on a German precedent, not from the digital age, of course, perhaps in a controversial way. And it was leading us in a way, perhaps that was not very helpful in the end. Whereas now, really, we are looking at the real issue here as the issue of choice. Okay? So the issue of choice would mean it's even beyond consent, is the choice. So it means you are dominant, you need to leave the possibility to consumers to decide the level of personalization. I mean, so it's really, so what type of services you want. So I think it's really, quite really looking into the future, looking really what's the problem, and also President Andreas Munter again said, what's the real issue here? It's about the fact that we get to have to go to the core of the problem. The core of the problem lies exactly there. And so it's really pointing us in the right direction, mentioning what's really important, so the possibility of choosing, and the possibility of choosing, really exercising our real right to privacy, which means the data to the level of intrusion that we want, level of creepiness, basically. So we can really decide about it, and we should really decide it, and the undertakings in dominant position should really offer the possibility of choosing. So that raises quite a lot of interesting questions, of course, and that would be, so it's not only elegant, it's forward-looking, it's pointing to different perspectives, and quite a lot of thinking needs to be done now, I think, based on this decision.
Is it imaginable that maybe the Hellenic Competition Authority would address the similar question? I mean, it's not a polite question. Maybe some other national competition authorities.
Theoretically speaking and hypothetically, possibly. And I think what was interesting, actually, what was most interesting in the Facebook case was actually the remedy, I thought. Because what actually really happened there is a form of ecosystem data breakup. This is how we call it. Because the remedy, without necessarily doing a breakup, because this is obviously going to be impossible for political reasons for a small authority like ours to do. It certainly enabled it somehow broke the ecosystem of Facebook, which is a third-party ecosystem to a certain extent, because you have actually independent companies that are participating to the ecosystem that create all these, where Facebook put their cookies, etc., where they were harvesting data, and for these type of data harvests from these companies, there was actually this requirement, the idea that this was actually anti-competitive. So from that perspective, there was a separation between the core, let's say, Facebook services and those actually that are not owned by Facebook. And I think that was an interesting remedy. With regard to the theory of harm, I would say, the difference I would see between the Bundeskartellamt case and the the last actually judgment, is that the Bundeskartellamt case, interestingly, went to enforce competition law, but actually with regards to the theory of harm, really borrowed heavily, and actually did not even borrowed, actually did actually a GDPR type of analysis, claiming that.
Jonas, just short, do we really need proof of harm in this respect when it comes to privacy? That's also a relevant issue, I believe.
It was actually a competition law case, so you have actually to prove some form of harm, right? From that perspective. So, and I guess in privacy too. There is obviously some form of harm to establish under the criteria of legality are very different in privacy and competition law. Well, in this case, actually, it's quite interesting because the Bundeskartellamt went and implemented the criteria of legality of privacy law when they were dealing with a competition law case. And I think what the judgment of the court tried to correct is that they said, okay, you might actually be inspired by privacy principles when you are trying to determine a theory of harm based on privacy in competition law, but it has to be a competition law theory of privacy. So, and I think that was, the main difference between the two cases, at least the way actually I understood them.
We all heard that maybe we expect at some time that this case will land in Luxembourg, who knows. Aline, you have a clear view on the theory of harm, I believe.
Yes, and I would say, you asked what's the harm to competition, and if we talk about exploitation, you don't need harm to competition. You need harm to come from the lack of competition. So, and what also the Federal Supreme Court has now said is basically their theory of harm, is related to choice, and they say that if there had been a more competitive setting, they would have expected more privacy-friendly choices to be provided in the market.
But in your latest article, you found out that there is simply no competition on privacy, if I remember well.
Well, I think the fact that we have really little competition on privacy is driven not just by competitive failure, but also by the lack of incentives to actually compete on privacy. But I think the lack of competition can make that worse. So so the question is, if there are more options in the market, does that already give you the choice, even if those choices are all equally bad? I think if they're all equally bad, well, then the choice probably doesn't really give you that much, but you still have. But I think in most markets you see some slightly differentiated offerings, at least. However, I think everybody's now talking very positively about how the Facebook case has turned out, and I think everybody kind of likes the Federal Supreme Court decision. I think there are still some open questions there. So they also, because they not only talk about exploitation, but they also talk about exclusionary conduct, and they somehow link the two, but to me, it's not really clear to what extent one requires the other for this to be a competition case. There's kind of a slight, well, I think some people are suspecting this, but it's not really clear yet. And well, maybe, you know, the case may be running for a few more years. But at the moment, it's kind of in the air. So there's somehow some exclusionary effect on advertising markets, but there's no evidence, and I find this pretty tricky because basically the Bundeskartellamt case was a pretty different one. So now we are running this case with really little evidence on what the current theory of harm is, and there's also not much clarity on how the two different theories of harm interact, and that's one of the reasons why I think the Facebook case is doing great in terms of, you know, attracting attention to the problem, but I also have lots of sympathy for this kind of more UK approach of having a market study that is more targeted at bringing out structural problems, which I think we haven't really done yet in this Facebook case. I think we have a slight suspicion that other players might fall foul of the same problems, but we don't really know yet. Kind of, we first exercise the whole thing with Facebook, and then kind of when we see the results, I guess we'll see who else we can apply them to.
Many thanks, Celine. Irrespective of the reasoning in the board decisions, the same question to Wolfgang and Sebastian. Where do you see the convincing theory of harm in this case?
Yeah, I mean, the theory of harm, I think, is clear. There are two harms. The one is the harm to privacy, and the one is the other to competition. And the one to privacy is very clearly that because they are bundling this, and the consumers have no choice and have to accept or have to consent to the bundling of all this data and these very comprehensive consumer profiles.
But Wolfgang, maybe the consumer likes it. Who knows? I mean, I don't have the feeling that many consumers are complaining.
Yeah, but the point is that they have no choice whether they like it or not.
Okay.
And there might be some they like it and others they don't like it. And that's exactly the point.
I'm not saying that Facebook is a perfect machine. But I don't have the feeling that many consumers are aware that they are, at the end of the day, worst by using that machine.
I mean, this is a second market failure. This is an additional market failure. And that was my point, and we have to look at both at the same time. And that was also a point of the Bundeskartellamt. They also mentioned the problem of information problems and that they are not aware of this. But this only strengthens the argument. So the point is that there are, and this was also the point at the Federal Court of Justice, that they said there are two groups. There might be two groups of consumers, and one they are private sensitive and the others they are not. And the private sensitives, they have no choice, and therefore there is consumer harm. And I have no problem as an economist to say this is negative for consumer welfare, and therefore I can bring this into a consumer welfare standard. It's not a problem. And so in that respect, we have an exploitative abuse. And for exploitative abuse, I don't need any kind of negative effects on competition. Yeah, it's negative for the consumers, and this is sufficient. as an exploitative abuse. The second is, and linking this, because, and to the question whether Facebook, and we also talk about Google, this would be a similar case, that they get through this bundling a lot of more data, and therefore have a data advantage. And this is now the discussion we have now in the last more than one year about the digital market, about the digital advertising markets. And you only have to look at the CMA study, and they make very clearly exactly the theory of harm, that these kind of data advantages lead then to barriers to entry and lead to a distortion of competition on the advertising market. So in that respect, these are the two theories of harm. The question is, to what extent can you really prove it? But this is a theory of harm. What I would like, but also to emphasize is, when we go back to the Federal Court of Justice, because this was here discussed a lot, I thought it very important, this idea that we have this constitutionally protected basic right of informational self-determination. This was the argument, which is the same as we have privacy as fundamental value at the EU level. And what the Bundesgerichtshof says is that this means that the consumers have a right to substantially participate in decisions how their data are used. And this substantial participation in the decision, this is not possible anymore through the behavior of Facebook. That's the argument. And therefore, this is, in my sense, primarily still an exploitative abuse case. And therefore, and this is the main argument, and I think this is a very good argument, and therefore I think this is a very convincing case, and I think therefore this might also be, I think this will go up to the European Court of Justice. This then might also be a violation of Article 102, and this is discussed. And I think this is very important. The point is now. The question is, there's one specific additional paragraph in the decision of the Federal Court of Justice, and this is that the social media platform of Facebook is not only dominant, but is also somehow unavoidable for part of the population, so you cannot avoid it anymore. So it's something more than dominant. It's a kind of an infrastructure-like communication platform for the society. And then the court says this leads to special responsibilities also for the conditions to access this. And I think this is interesting that this is perhaps more than dominance what is required for this also kind of remedy. And I think this is perhaps interesting, thinking about more what does this mean.
I absolutely agree with you. I'm just laughing because I wish one day the same way of reasoning when it comes to open data in Europe. But that's completely different subject. The same question to you, Sebastian. Theory of harm. Do you feel convinced by the recent judgments?
This is about my feelings.
Feelings matter.
Yeah. Yes, but first, yes, but in 3 points. First, I really favor with Aline's thinking about privacy as a quality matter. I understand it as this. This is a really, I think this is something we should always recognize. And it had been a little bit recognized by the Higher Regional Court of Düsseldorf, I suppose. But in the wrong way. The Higher Regional Court said something like, everybody is free just to choose another platform, and this is something thinking about quality and privacy aspect. This was overruled by the Federal Court, but it was the thinking based in Section 19 in this as-if concept, like comparing the market with another narrow market. We don't have narrow markets, as you said. It's just a problem like where's the market just to compare. This is the first. And the second, now back to your question, I'm convinced in that way that the BGH just fostered it's this recent case law about this abuse of conditions because of maybe some people know VWL Gegenwert 1 and 2. These are case law from several years ago. It dealt with this kind of abusive of conditions in terms and condition cases. And it was used by the Bundeskartellamt in founding the Facebook case. And the Facebook case started in this kind of infringement. Data protection law is competition law infringement. And now the federal court said it is just not necessary to assess this question. It is more necessary to ask what is competition in that way and what is based the balancing of interest. And the balancing of interest thing, this is the result of what I would say is the theory of harm we should work with, because this is the question, what is the interest we could take into this balancing process? The privacy interesting, maybe not, but maybe the personality processing, like the freedom of choice. This is my theory of harm I would define. And you asked something about this, what if the consumers doesn't want, or just it's just not a problem for them, just they want to be exploited. This is something I want to maybe think about. This some German federal or constitutional court cases. We have some case law in this waiving up our constitutional rights. We have Zwergenweitwurf, Bundesverfassungsgericht. It is people, they're saying, throw me, I'm just a small guy, throw me because of the fun of other people. And we have the discussion about this. Is this against fundamental right? I guess we could take a little bit of these arguments to our Facebook thinking and think about whether it is possible to waive up constitutional and fundamental rights in these Facebook cases, in this theory of harm, and that will lead us to a balancing of interest where it might be not possible.
I really like the reasoning where they say that also by the way of processing data, also the competition on the market is affected, because the new entrants, they don't have the equal level playing field when it comes to developing new product or whatsoever. With a view on the time, do we have maybe comments, questions in the audience? And I see Oshrit, as I already said, the co-author of the paper with Professor Michael Gal from Tel Aviv or Haifa,
Tel Aviv.
pardon.
Haifa and Tel Aviv.
Yeah. Please.
Thank you. Actually, I have two notes more than comments, but I would love to hear your view. One of them is a little bit commenting about the small dialogue you had, Pencho, with Wolfgang about Facebook, as an example. And you were mentioning that the consumer can choose whether they want to give whether they want the trade-off of the data versus the services. And I want to be a little bit the devil's advocate here, and the consumer always has a choice. So if they choose to give Facebook the data in exchange of free services, I think the consumer always has a choice. But again, it's being a little bit of devil's advocate. And the second point is that I think it's really important to emphasize that if Facebook is being taken as the only use case, as online advertising, social media, and all the examples that people mention here, I think it's really dangerous to look at Facebook as the only use case, because I think Facebook specifically implies poorly on the ad tech ecosystem. And all the consequences as a result of Facebook's behavior, the entire ecosystem should pay the price. And I think at the end of the day, that empowers Facebook on the competition playing field. At the end of the day, when you explore the entire value chain and you see how these types of regulation versus court ruling, at the end of the day, not necessarily dispowering Facebook, but actually dispowering the ecosystem behind it. There was a note, but I would love to hear your view on that. And maybe a second small note that refers to the first question that you were asking Simonetta about, was there any positive effect on competition that GDPR creates? And despite the fact that my general notion is that the GDPR did empower the big players, I still think that the GDPR created new markets and new ecosystems, exactly the points where you mentioned that not necessarily. GDPR created new professions, and it created new ecosystem for privacy tools. So I think that's worth mentioning as the positive effect on competition. Beside that, I'm the advocate of exactly the opposite, so that's it.
I think you have enough inspiration for the comment of Oshrit. But maybe we take one more comment from by Torsten, if it's possible. Short, Torsten.
Of course, as always.
Every time.
As always. So, for good reasons, the Commission made the decision to take privacy data not as intellectual property. But on the other hand, we are dealing like with intellectual property. So when I'm handing over my data to Facebook, it is on the positive side of their balance. But when I'm taking in consideration that I can take it back, is it not that I'm borrowing my data to Facebook? Should it be not done on the negative side? So can we not fix that whole issue by just a simple change of international accounting law saying, hey, if somebody's giving me data, is it not an asset? It is a loan. Because I have to give it back. That will generate an insight to make decisions on as less data as possible, because otherwise my balance is going down.
Yeah, of course.
I would like to briefly take up one point from you and also to you. So just very briefly on the question of does Facebook actually reflect poorly on the ad tech industry? I believe it doesn't. I believe it's a very good example of how the ad tech industry works, and it may not even be the worst. I mean, people have been looking into data brokers for some years now and haven't really come up with a fix. But somehow everybody who looks at it goes like, ooh, this is really bad. I mean, there are companies who just live off data and selling really detailed profiles about pretty much everyone on the planet and trying to kind of make the most money out of it that's possible. So Facebook is monetizing that quite cleverly, and a lot of people in this ad tech stack are dependent on Facebook. Yes, but I'm not sure the world becomes a worse place if we take some money out from that and go from very much targeted, personally targeted content to, for example, more contextual advertising. And I have some hope that we see some actual effort in that direction, maybe also with the upcoming regulation. And the other point, should we somehow fix the balancing sheet? I think, just a very brief point is, I think people don't necessarily primarily want more money for their data. I believe this
that was not my point. That was not my point.
And they don't. Facebook wouldn't have to give the. I mean, I think it's not about money. I think it's about thinking how we set incentives such that data is used in a way that benefits consumers rather than exposes them to more risk. And I think for that we can, there are a lot of potential mechanisms we can use. But I think maybe Yannis can also come back to that, because maybe I think you have a slightly different view on that. I think it's not primarily about kind of getting markets to work such that consumers get more data, get more money. I think they actually want more influence and should have, and their interests should be more at the center of what happens with their data. Or maybe we're on the same page.
Sorry, I guess we didn't understand us here completely. It's about the evaluation of the company. It's not about the money for the consumer. The stock market is driven by data. So if this is not on the positive side, first of all, the liquidity of these evil folks is going down dramatically. Yeah? And secondly, that is generating a totally different incentive. It is saying, be careful with data of humans, then your balancing is going up. It is not about giving money to people. It's about evaluation drivers of companies.
Okay, please let's focus maybe on these remarks by Oshrit and close the discussion slowly. I would start with Ioannis. Maybe you can comment on the issue, on the questions,
issues? Yeah,
for sure. And maybe at the end, like a final remark, do you believe that the current coexistence of the GDPR with the competition framework is enough to deal in the future more in a more concrete way in cases like Facebook?
All right. So with regards to the first question, I think from you, so I think there is an issue that we have to take into account is that the consumer doesn't have, the user actually, doesn't really have knowledge about the value of their data. They don't really have information about what's going on the advertising market between basically Facebook, Google, and the advertisers. So this is really something that is certainly missing, and to a certain extent might be an important problem if we actually want to have a fair exchange. And I bring again the issue of fairness. I think it is actually what probably also might motivate. It's not just an efficiency story. It's also, I think, an issue of fairness. What might motivate also this type of approach. Secondly, I would say that what is probably the problem in these markets is the fact that the current situation might lead to to mistrust and to an institutional problem for the specific market. Which means that the consumers will have more difficulties to, provide their data, in particular, to newcomers, because, Facebook and Google, they have already their data, so, they will not necessarily, it's a marginal, utility for them to provide a little bit more, but, if it's a new player, why should we provide the data there? And I think, to a certain extent, there is an issue of legal code that we need actually to take into account. I mentioned the term legal code, taking this term from Katerina Pistor's basically book about the code of capital, because I think what is really happening here is, we have not established at the beginning of this industry the right legal code, which was to provide property rights on the data. So what actually we enabled was a sort of, possession of that data provides. It was enough. And this is exactly what led to the fact that we had, the emergence of these giants with important network effects and learning effects. And I think the learning effect is much more important than the network effect here. And why is that? Because the more data they harvest, the more market power actually they get, the better actually they make predictions, and therefore the more valuable they are in the advertising market. And this is basically a circle that continues. And I think here we did not have the legal code at the beginning. So the GDPR, and I agree with a paper by Michal and
Oshrit.
Oh, exactly. I think they mentioned something which is absolutely, I think, right. At least there is some evidence that it's happening. So the GDPR possibly might lead to reduced competition to a certain extent. However, I think what is important here is not to have a little bit of a natural market idea, and I take a little bit of that from Michael Harcourt. We cannot compare that, because what is the counterfactual here? I don't think really the counterfactual here is a market which is unburdened by data protection regulation. That's the wrong counterfactual, because the counterfactual here is a market where, in case we did not have the GDPR, actually the market might have collapsed because of the fact that consumers would not necessarily have trust in providing their data. So I think we have to be very careful in the way we assess the competitive effects of the GDPR and the counterfactuals actually we have in mind when we write something like that.
Clear statement. Many thanks, Ioannis. Simonetta, maybe we continue with you.
Sorry, the question?
The question would be your final remarks, and maybe you can also send some clear messages for some future cases. Does this framework suffice to deal with potential new cases like Facebook, or you see a problem somewhere?
There are always problems. But the thing is, I think, as I said, this decision by the German Federal Court has been very helpful. As I said, as an academic now, I already think about it, and I think it's showing us, as I said, interesting direction. I think, as Wolfgang Kerber, many others here have said, we need to think more of possible intertwined effects. Okay, but also positive. There are some interesting dynamics going on. For instance, when you think about access to data, okay, that would be, of course, one of the remedies. Okay, and then, of course, you have to think about how you make it. And I'm not sure that the GDPR is going to be an obstacle to that, because, of course, the GDPR, as the coronavirus has shown with the apps, could actually be quite flexible. There is a public interest, perhaps, also that the competition authorities can refer to say, well, you need access to data because, for instance, the case of Google search engine, as the CMA has actually written in the big Bible, their report on digital platforms and online advertising, you need it. So what type of access to data? And they've said, okay, you need access to click data, et cetera, and then they can say, well, it's covered by the GDPR, it's perfectly compliant with the GDPR because of the public interest. At the same time, the GDPR is telling competition authorities how to do it, because GDPR isn't only about consent, not at all. They would just one principle, that's lawfulness. There is the whole array of other principles after that, in which I think the perspective of competition authorities and data protection authorities could actually come pretty near, and we need more collaboration and thinking in that direction.
Many thanks. Professor Kerber, Sebastian, and we finish with Aline at the end.
Yeah, I would like to continue. I think also, as also Johannes had said, both laws are complementary. And I think we have to much more analyze the interaction between these both laws. So one, also what you can mention is data portability. Data portability, really, we are discussing right now enhancing this for promoting competition. But this is part of data protection law. So in that respect, you have real interaction effects between these two laws, and we have to think about how we are dealing with this on both sides. And what I think is interesting is you can look at the remedies of Facebook case. We have not talked about the remedies really. Do the remedies really work? Because it's not really an unbundling. You only get an additional consent. So the consumers have to consent. It's not really an unbundling.
But
so if only
maybe to add to that, will Facebook be at all in a position to function if we implement these remedies?
Certainly, why not? It's not a problem at all.
I'm not sure. How will they know what I was looking for the day before? How will they know that potentially Aline is a friend of Simonetta? How will they find out that I am preferring Nestle products more than, I don't know. If we really unbundle the whole...
I think it's not a problem.
They can buy it's technically not possible. What is technically not possible?
If what he said will be, if they try to implement that, the whole policy engine of Facebook will not work anymore. No chance.
Why is that?
Because it is how it is implemented. That's tech stuff, not law stuff. They have several layers, and one of these is exactly what he said, is these consent management. And this layer is not like a vertical layer, it's a horizontal one. And so when you're not able to handle that in that way, how they're doing that today, all the other layers have no fundament anymore. It will just collapse at once.
We're not talking about the core Facebook business.
No.
I mean, we don't talk about the core Facebook owned, basically.
But what he is talking about is one of the core functionality of Facebook.
It
is code.
Facebook used to work quite well even before it implemented those features.
Sorry for interrupting you. I didn't want it to go in that direction. Please, Professor Gerber, please continue it.
No, my point is that the remedy is only giving the consumer an additional consent. And if not enough consumers reject this consent but accept it, then there is no real effect, for example, on the exclusionary effects. Then Facebook has the same amount of data than before on the advertising market. So this does not help the exclusionary effects. It might help the exploitative effects, and that we have enough choice, but only if really the consumers are not suffering from the second market failure. Because if they are not well informed and they are overwhelmed by choice, then this also doesn't help them. So in that respect, it's not at all clear whether the remedies now really, in the Facebook case, are effective for exploitative and exclusive abuse. So in that respect, what we need also to solve the second market failure. And this means that competition law is not enough for solving this. And this is a very important point, that we need also data protection law and consumer law for solving the problem. And this is what I mean, that we have to also, need a more integrative approach between the both policies, and they have really also to collaborate with each other. So we need a collaboration between competition law, consumer law, and data protection law, and also the agencies have to collaborate, because what we need, if we have simultaneously two market failures, then we need a good combination of remedies for both market failures, and therefore we need this from different policies at the same time. And I think this is also an important lesson that we should also learn from that. It's competition law itself might also not be sufficient.
Exactly. Many thanks. Do you see, Sebastian, the same double market failure?
First, some short clarification because of this intervention of you. The Facebook case was just relating to off-platform data. I guess we should talk about this. This is typical lawyer stuff. Now talking about this is the case and this is not the case. It was not decided about this on Facebook data. Now we have to talk about the questions relating to this, but we don't. Now to your
but not only offsite. They're mixing the various
yes,
sources.
they are doing offsite together with onsite, or
exactly.
off platform with on platform. And that was the antitrust case, mixing together. Without mixing together, it's just Facebook. I guess we agree in this case that it will function like before. It's not the antitrust case in this way. Now my final remarks. First, I agree with Ioannis and Wolfgang Kerber, and maybe with Simonetta in one of the first sentences like this. We should assess more the factual effects of privacy and competition, but we should separate competition law and privacy law. The two law systems we should separate, but we should bring together the effects. And the effects are just empirical stuff. And the second one is just something in my mind. Maybe we should think about this, putting this idea in empowering the consumer more, giving more market instruments, like from the grassroots, just to minimize the market power of platforms. Maybe this could be an instrument just empowering of consumers.
We're talking about that issue tomorrow, how to empower citizens more, when we talk about a new concept of data trust in Europe, or maybe some also connected issue of data altruism. Yeah, the final remarks go to, we start with you and we finish with you, Aline.
I'll give my best. I hope everyone's still awake. I think the remedies of the Facebook case can actually be really great if they're implemented well. And I would like to see them implemented more structurally across markets where we have the same problem. So I would like to see higher barriers for sharing data, sharing personal data internally, and that might even help to mitigate some of the effects of the GDPR, which sometimes can actually favor concentration in certain markets. But at the same time, I also think it's important for competition authorities to also, well, move forward and think about privacy implications. I think at the same time, it would be great to see more conditions that would help foster competition on privacy. And that's one of the points you mentioned. Yeah. In many cases, I mean, in many markets, we don't have concentration, but we still don't get proper privacy outcomes. And that's because we still don't have real transparency, even though we have a lot of provisions in the GDPR which haven't really been made use of. We also, well, we have portability in the GDPR, but it's not really made to work for competition. So I think we really need to think much more about real-time portability using APIs and so on. And only then I think we'll see more services that actually serve consumers much better and give more choice on privacy.
Final statements. I couldn't make it better. Many thanks for staying with us at 10:30. It was a really late night show, competition and privacy. I really enjoyed. It's hardly to imagine that the next session is in less than 12 hours tomorrow. But I really appreciate your presence. Especially many thanks again to our European guests, to Natalie, to Ioannis, to Simonetta. Let's get together in a Corona modus without alcohol. I really appreciate your time and many thanks. We see you tomorrow with the European strategy on data. Many thanks.